Yes. Explain. ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಬೇಕು? ಹಳೆ ಅಯ್ಯ 33 ತಾನೆ. ಹೇಳಿದಾರ ಹರ್ಷ ಅವ್ರಿಗೆ ಹೇಳಿದಾರ?
For responding. ಅದು LCR ಬೇಕು. Question of liability. You were traveling on the bumper of the tractor trail.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ. ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, ಓನರ್. Owner has come up in appeal.
This to R1 delay of 91 days. Filing is confirmed. New India ಯಾರು? New India. Their revision to take notice for R2. Notice to R1 and R2 dispense with the request of the appellant's counsel. Yes, it is. Filing is confirmed.
I prefer appellant in this case, Miller. There is a connected matter filed by the petitioners also in MFA number 4997 of 19. Erdu next week dispose ಮಾಡ್ತಾರೆ ಸರ್. ಅವರು ರವಿಶಂಕರ್ ಇದ್ದಾರೆ.
ಅದು ಡಿಪಿ ಮುಂದೆ ಬರುತ್ತಂತೆ.
ಯಾಕಂದ್ರೆ ಇದು ಎರಡು ಜೊತೆಯಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ. ಅವ್ರ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಸರ್. ಅರ್ಧ ಹಾಫ್ ಅಮೌಂಟ್ ವಿಡ್ರಾ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀವಿ.
ಏನು ವಾಟ್ ಇಸ್ ದಿ ಗ್ರೌಂಡ್?
Nandu negligence is on the part of the rider of the petitioner himself, deceased himself.
Accident took place how?
Because he was taking coming to the highway from the side way. As per spot sketch, it's clear that he was coming onto the highway from the side roads, and the insured car which was coming on the highway, he obstructed the flow of the car, and thus the insured bike came to contact with the car. ಅಲ್ಲ, ಇದರಲ್ಲಿ ಲೋಯರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಒಂದ್ಸರಿ ನೋಡ್ಬಿಟ್ರೆ ಅದು ಕ್ಲಿಯರ್ ಆಗಿ ಇದಾಗುತ್ತೆ. Some amount of negligence has to be fixed on the petitioner, the deceased himself.
ರಿಪೋರ್ಟ್ ಇದೆ ನಿಮಗೆ? MV ರಿಪೋರ್ಟ್ ಇದೆಯಾ? Produce a spot sketch and IMV report and dispose it of. Because the deposit amount upload, the appellant is permitted to withdraw 50% of the amount deposit. Awaiting TCR ಅಂತ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಬೇಕಾದ್ರೆ ಎರಡು ಮುಗಿಸ್ಬೋದು.
ಅದ ಡಿಬಿ ಮುಂದೆ ಅದ್ರ ಮುಗಿಸಕ್ಕಾಗಲ್ವಲ್ಲ ನಾನು?
ಯಾಕಂದ್ರೆ ಎರಡು ಜೊತೆಯಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ವಾಸಿ ಅಂತ ಅಷ್ಟೇ ನನಗೆ.
ಬಟ್ goes along with MFA numbers.
Submission, my lord. One submission, my lord. Serial number 22, my lord. I pray for 1 week time, my lord.
My good God.
And appeal number 12, how can you make a mention like this?
Sorry, my lord.
Number 13, notice to R1 and R3, dispense with at the risk of the opponent. Day of truth and prejudice, filing conduct. 14, same notice to R1, dispense with the risk of the Who's R1? 1 week. Same R1. R1 counsel is permitted to take court. Fresh publication in the newspaper showing the date of hearing as on. Publication be made on or before. Again, nothing that's allowed with them. Will objection. Show the name of the counsel. Prakasha as appearing for the appellant. Delete the name of the RC Nagaraj. Till is next day.
I appeal for appellate in this case, my lord. My lord, this appeal is by the insurer challenging the liability to pay the compensation.
Round of liability or quantum? Ready na?
ರೆಡಿ ಇದೀನಿ ಸರ್. ಇದರಲ್ಲಿ ಗ್ರಾಟ್ಯಸ್ ಪಂಚಸ್ ಟೆಂಪಲ್ ಹೋಗ್ಬಿಟ್ಟು ವಾಪಸ್ ಬರ್ತಾ ಇರೋ ಆಗಿರೋದು ಇದು.
Where is it listed?
ಅಲ್ಲ ಇದರಲ್ಲಿ ನಂಗೆ ಗಂಟ್ಲು ಪೂರ್ತಿ ಥ್ರೋಟ್ ಇದಾಗ್ಬಿಟ್ಟಿದೆ. ಸೊ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಥ್ರೋಟ್ ಪೂರ್ತಿ ಇದಾಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಬರಕ್ ಆಗ್ತಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಕೌಂಟ್ ಮಾಡ್ತೀನಿ.
Question of liability permitting you to withdraw may be difficult. So
ಗ್ರಾಟ್ಯಸ್ passengers.
go to the division. File a memo in the office.
I'm sorry, ನಾನು ತುಂಬಾ ಥ್ರೋಟ್ ಇದಾಗ್ಬಿಟ್ಟು ಸೋ ಥ್ರೋಟ್ ಆಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಬರಕ್ಕಾಗಿಲ್ಲ.
Liability records check. ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಏನಂತೀನಿ reasons stated in IA reasons stated in the upload accompanying IA2 the order dated 11/2020 is recalled in the application to file condition of delay. The application to condone the delay is also allowed. ಇದು 2,500 ದಿನ ಇದೆ. ದಿನ ತುಂಬಾ ಆಗೋಯ್ತು. ಎಷ್ಟು ವರ್ಷ ಆಗೋಯ್ತು? Notwithstanding the order dated 10th of February 2050, the appellant is permitted to comply with the officer. Comply ಮಾಡಿ. List next day. The reasons stated in IA 1/19, they have 1 to 77 days following the appeal is condoned. However, the appellant shall not be entitled for the interest on this delayed period of 1277 days. Condone. Condone. ಯಾರಿಗೆ? She so and so submits that he has entered appearance for admit call for records. Delay of 119 days. Condone. Admit call for records. 23.1 delay condone. Delay 12 days condone. Permission to withdraw. Liability na quantum. Next page. Delay condone. 26 delay condone, no interest. Same 27. 28. No, 25, 26. Admit call for records.
26 ಅಲ್ಲ FF ರೆಸ್ಪಾಂಡ್. ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರಿಸಸ್. 26 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ. 26 ಅಲ್ಲಿ ನಮ್ದು ಕಂಪನಿ ಅಪೀಲ್ಸ್ 2086, 2087, 4238 of 18. ನಾನು ಮೆಮೊ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ ಆಫೀಸಲ್ಲಿ.
2086, 2087 ಆಮೇಲೆ
4238 of 18 ಕಂಪನಿ ಅಪೀಲ್ಸ್ ಇದು. ಅವ್ರ ಅಪೀಲ್ಸ್ 542 of 18, 543 of 18 and present appeal ಇದೊಂದು 7231.
ಮೇಡಮ್ what's along with the numbers from next week? 29. Everyone for 2020 dismiss is not present. Admit call for records. Is also to take notice for the insurer. Vijay Kumar ಅವರೇ,
My lord, ಇದರಲ್ಲಿ 50% of 50% may be permitted to withdraw. Records may be called for, it can be disposed of also.
ಏನ್ ಗ್ರೌಂಡ್?
ನಮ್ದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಮತ್ತೆ ಕ್ವಾಂಟಮ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ 15 lakh ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಇಂಜುರಿ ಕೇಸ್, ಸಿಂಪಲ್ ಇಂಜುರಿ. ಬಟ್ ಡಿಲೇ ಆಗೋದು ಬೇಡ ಲೇಡಿ ಅಂತ ಹೇಳಿ ನಾನು ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಆಕ್ಚುಲಿ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಒನ್ಸ್ ಫಾರ್ ಆಲ್ ಇಫ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಅವೈಲೇಬಲ್.
ಕನೆಕ್ಟೆಡ್ ಮಾಡ್ರಿ, ಯಾರು ಹಾಕಿರೋದು ನೀವೇನಾ?
ಅವ್ರ ಕ್ಲೈಮೇಟ್ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
notice for every respondent. Respondent.
Permitted to withdraw. 50% is permitted to withdraw.
IA1 stay. There shall be a stay of the improved award subject to the applicant depositing the entire amount along with interest before this court. From such deposit, the registered to invest the amount in a fixed deposit. 33 same, so 30 to 33. 34 notice. Insurer ಯಾರಿದಾರ?
36 I'll take notice, my lord. 36 I'll take.
Not
Notice
37.
ಮಾಡಿ.
ಅಲ್ಲ 36 I'll take notice for R2. R1, sorry.
36 ಅಲ್ಲ?
Yes.
Vijay Kumar takes notice for R2.
R1.
Not 37. I appeal for the respondent number 4, my lords.
Yes.
I seek 2 days time, my lords. I'll file documents. It can be taken up next week, my lords.
I'll give you time on 2 occasions already.
Please, as a last chance, my lords, it may be kindly.
Monday,
Please.
Monday. Last chance.
22.
ಅವರು 2 ದಿನ ಕೇಳಿದ್ರು ನಾನು ಜಾಸ್ತಿ ಕೊಡ್ತೀನಿ. ಇದೇ ಕಂಟ್ರೋಲ್. On the ground. On the ground. Why owner? Actual person. Ability to fix our pain recovery. ಆದ್ರೂ ಪಾಲಿಸಿ ಕಂಡೀಷನ್ ಬ್ರೀಚ್ ತಾನೆ. ಕವರೇಜ್ ಇಲ್ಲ ಒಪ್ಕೊಳ್ತೀನಿ, ಬಟ್ that is a breach of a policy condition. The policy condition is, therefore, if that is violated. ಲೈಬಿಲಿಟಿ ಬರಲ್ಲ, ಕರೆಕ್ಟ್. ಬಟ್ ನೀವು ಪೇನ್ ರಿಕವರಿ ತಾನೆ. ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ the same, isn't it? 147 ನಲ್ಲಿ that is one of the grounds. No, the grounds. See the grounds. Yeah. Limits of liability is this, correct? Then read subclause. One 149(2). 149(2). This is the defense that you can. That is the limits of liability. 149(2) is what. Correct. You're not required to cover it. But if the vehicle is insured and if there's a breach of this 149(2), permit go agayega. I'm bound by the full bench then. ಅವರ ಪಾಯಿಂಟ್ ಇದೆ ಅಲ್ವಾ? ಇಲ್ಲ 147 ನಲ್ಲಿ ಕವರೇಜ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅವಾಗ ಬ್ರೀಚ್ ಬರಲ್ಲ ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಅಲ್ಲ. ಎಲ್ಲಿದೆ?
ಅಂದ್ರೆ ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ 22 Last year, hence by virtue of the above regulation, the driver of the tractor is not permitted to carry.
Para 22 na.
22 next year. Income challenge na refer ಮಾಡಿದ್ದಾರೆ 2 lakh case. Airport was found that in favor of the responsibility to the tractor as a passenger because the tractor was used for not for carrying. Evidence and record find out that the legal
where is the reference to the judgment as such? ಯಾವ judgment ಹೇಳ್ತೀರಾ?
This is a judgment. ಕೆಳಗಡೆ ಪಾಠನ ಮಾಡಿಲ್ಲ. There are 22 ಪಾಠನ. On this aspect, I did not another in case of Surasutta is very relevant. There are 10 and 11 of these cases we have put yes, right there. And 11 again. At the same time, however, the facts of the present case, the High Court ought to have directed the incident to be really
ಇದ್ರ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ ನಂಗೆ ರೆಫರ್ ಮಾಡೋದು ಅರೆ 10 ಅದೆಲ್ಲ ಇದೆ ಜಜ್ಮೆಂಟ್ ಆ ರೆಫರೆನ್ಸ್ ಸಿಗ್ತದೆ ನನಗೆ ಶಿವರಾಜ ಯಾವ ವರ್ಷದ್ದು? 2018-10 SEC. Same pay and recovery ಆಗಿದೆ. Same case. Same. Have they said that pay and recovery not apply here? As a full bench said that. Liability owner ಮೇಲೆ ಬರುತ್ತೆ ಅದನ್ನ ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅದನ್ನೇ ಹೇಳೋದು. But pay and recovery ಅಡಾಪ್ಟ್ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿದಾರ. Correct. Even now I am saying owner is liable. But if the vehicle is insured according to this judge. But ಇದೆಲ್ಲ ಹೆಂಗ್ ಮಾಡೋದು? Supreme Court dealing with an identical case, traveling on a tractor in a tractor trailer, has said that the owner alone is liable. Injury you are not liable, but still they have said you have to pay and recover. Full bench al bada nan full bench follow madla Supreme Court follow illa refer ಮಾಡಿ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಾ pay and recovery ಮಾಡಬಾರದು ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿದಾರ. ಇಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ ಇಲ್ವಾ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಬಾರದು ಅಂತ? ಏನು reference was made that has been answered. Matter has been sent back to the respective benches. The question of law that has been answered is if you are traveling on a tractor, the owner alone is liable. But has it been said anywhere that pay and recovery should not be adopted? ಅದನ್ನ ಅವ್ರು ಒಪ್ಕೊಳ್ತಾರಲ್ಲ. Then I'll follow this, take it to Supreme Court, get a decision. Correct. But the Supreme Court ಗೊತ್ತಿತ್ತಲ್ಲ. Supreme Court ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಪ್ಪು ಅಂತ ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ನೀವ್ ಹೇಳ್ತಿರೋದು ಅಲ್ಟಿಮೇಟ್ ಲೆಕ್ಕದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿಂಗ್ ಮಾಡಬಾರ್ದಾಗಿತ್ತು ಅಲ್ವಾ? ದಟ್ ಈಸ್ ದಿ ಅಲ್ಟಿಮೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ವಾ? ಕೊಡಿ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡಬಾರ್ದು ಅಂತ ರಿಲೇಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಫಾಲೋ ಮಾಡ್ತೀನಿ, ವಜಾ ಮಾಡ್ತೀನಿ.
Serial number 37, madam. 37, madam.
Come in the case is called not in the middle.
I'm sorry, madam. I'm sorry.
Where is the respondent? Liability dispute ಅಲ್ಲಿ ಇಲ್ವಾ? Let him come. Ability. Mhesh ಅವರೇ,
$41 million.
ಪೇ ಅಂಡ್ ರಿಕವರಿನಾ?
ಇಲ್ಲ, ಅಲ್ಲಿ they no RC at all as on the date of the accident. Question of pay and recovery arise. It cannot be brought on the public road when the RC has expired. It is not renewed at all.
That's a breach of policy condition, isn't it?
ಅಲ್ಲ, breach of policy ಅಲ್ಲ, breach of ಇದು provisions of law. Breach of policy. Breach of policy is different from breach of law.
So you are saying if there's a breach of law, you are exonerated?
Now, therefore, my lord, the owner has been exonerated.
No. Owner has been exonerated.
Yes.
He's made liable alva.
Yes. Owner is made liable. The owner is made liable. The insurance company is exonerated.
Your only defense can be breach of policy conditions. You are not liable.
No, I am not saying breach of policy of condition. The vehicle was not renewed at all. Registration, my lord, it cannot be brought on the public road without the renewal.
Same fitness certificate tarne alva. If there's no fitness certificate, that means vehicle can't be played.
No. If the vehicle, my lord, breach of policy is different. Breach of law is different.
For a breach of law, are you exonerated under the policy?
Yes, my lord, because when he cannot bring the vehicle, my lord, on road legally, then, my lord, the insurance company will not be liable. Therefore, my lord, owner was held liable.
That is all. The appeal is by the owner. You are again, appeal is the claimant. In injury, na? ಕೊಟ್ಟಿದ್ದಾರೆ 2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರಲ್ವ? ಯಾವ ವರ್ಷದ ಆಕ್ಸಿಡೆಂಟ್? Where is the evidence? Page? Was he the treated doctor? Doctor was examined. Was he the treated doctor? Like 18%, 15% ತಗೊಂಡಿದ್ದಾರೆ ಏನು 3% ಕಮ್ಮಿ ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟು? ಒಂದೇ ಅಲ್ವಾ? How old was he? ಎಷ್ಟನೇ ಹಾಸ್ಪಿಟಲ್ ಇದೆ? $45,000 ಮಾಡ್ತೀನಿ. ಈ
Section 39 may kindly be looked into, not about a registration. Necessity for registration. No person shall drive any motor vehicle, and no owner of a motor vehicle shall cause or permit the vehicle to be driven in a public place or in other place unless the vehicle registered in accordance with this chapter.
So it has been registered. It was valid for a particular
Further, certificate of registration of the vehicle has not been suspended or cancelled or so and so. The renewal, my lord, life of a vehicle, my lord, is determined. Transport vehicle, private vehicle, 15 years. After the 15 years, my lord, he is bound to renew. If you are not renewed, my lord, then, my lord, the question of, my lord, the vehicle being brought on the public road, my lord, causing, my lord, the accident. In such case, my lord, the owner would be liable, not the insurance company.
The claimant is lucky. Challenging the word of the tribunal. Not only on the ground that the compensation awarded was inadequate, but also on the ground that the tribunal had erred in exonerating the insurer of liability. The accident in question is not in dispute. However, the insurer contends that since the vehicle, since the registration of the vehicle,
Finding is also in favor of by the tribunal. Finding is also in my favor.
lapsed, it will not be liable to indemnify the owner on the occurrence of an accident. The tribunal has accepted this contention of the insurer and absolved it of a liability and made the owner liable. It is the case of the learned counsel for the claimant that at best, if a vehicle is plied on the road without a valid registration, it would amount to an offense under the Motor Vehicles Act, for which the owner would be liable, but that would not exonerate the insurer of its liability. It is this contention that so long as there is a valid policy of insurance in force, the liability of the insurer cannot be absolved. Learned counsel for the insurer, CAS 9, Momash, submitted that Section 39 of the Motor Vehicles Act creates a bar for any vehicle to be used, to be driven in any public place unless it is registered in accordance with the provisions of Chapter 4. And since the registration had lapsed, the vehicle in question could not be driven on a public place, and consequently, the liability of the insurance company would also stand exonerated. It is to be stated here that it is not the case of the insurer that the vehicle was not registered. Section 39 only creates a bar for a vehicle to be driven in a public place without it being registered. The other two conditions that are mentioned in section 39 is that the certificate of registration has not been suspended or cancelled. Admittedly, it is nobody's case that the registration either been suspended or cancelled. In view of the fact that the vehicle had been registered, the bar under section 39 would not really be applicable in the present case. It is also to be stated here that assuming this argument is a valid argument, at best, it would amount to a breach of the conditions of the policy. And in such an event, it is settled law that the insurer will be bound to pay the compensation first and then recover the same from the owner of the offending vehicle. That is the CLFS case. With this view of the matter, the finding of the tribunal that the insurer was not liable cannot be sustained and it is accordingly set aside. It is made clear that the insurer would be liable for the compensation that is payable to the claimant. As far as enhancement is concerned, the tribunal has determined the monthly income of the victim of the claimant at rupees 4,500. Since there was no documentary evidence to ascertain the actual income, in such cases, it would be appropriate to apply the income determined by KSLSA, which for the year 2010 to rupees 4,500. The tribunal has assessed the permanent disability at 15%, which in my view is just and proper. Thus, as a consequence, the claimant went to some rupees 5,500 12 into 13 to 15%. The tribunal has awarded a sum of rupees 65,000 towards pain and suffering. In my view, this award is adequate and does not call for any enhancement. The tribunal has granted only a sum of rupees 10,000 towards loss of amenities. With regard to the fact that the claimant suffered 15% permanent disability, it would be appropriate to enhance the same to 25,000. The tribunal has awarded a sum of rupees 35,000 towards medical expenses, conveyance, food and nourishment. The tribunal has noticed that out of the 35,000 rupees awarded, 29,988 is towards the actual medical expenditure. It is thus awarded only about 5,000 towards food, conveyance and nourishment. It is not in dispute that the claimant was hospitalized for 27 days. That view of the matter would be appropriate to enhance this award from rupees 35,000 to 50,000. The tribunal has also awarded a sum of rupees 10,000 towards future medical expenses, which in my view is just and proper and is therefore affirmed. Consequently, the claimant is entitled to the following sums. It is made clear that the insurer shall pay this compensation to the claimant and thereafter proceed to recover the same from the owner of the offending.
My lord, in this case, my lord, there are other connected matters, my lord.
In connected,
MFA 2640/15
ಯಾರು ಹಾಕಿರೋದು?
ಅದು ನಾವು ಹಾಕಿದ್ವಿ, ಅವರು ಹಾಕಿದ್ದಾರೆ. ಟೋಟಲ್ ಇನ್ನ 4-5 ಕೇಸ್ ಇದೆ ಒಟ್ಟು ಟೋಟಲ್. ಅಲ್ಲಿ ಟೆಲ್ ದ ನಂಬರ್ ಮೇಲೆ.
Serial number
2640/15, 1497/15, 1499/15, 1498/15, 2638/15, 2639/15. Totally another 6 cases are there. Shall I repeat the numbers, my lord?
1 minute. All of them are to the same extent.
Yes.
Have it together. Number
2640/15, 1497/15, 1498/15, 1499/15, 2638/15, 2639/15.
next week.
Please, my lord.
Insurance ilva? Accident occurred between? Their tractor trailer ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ liability. You were passenger in the auto and you filed the petition against whom? You did not make the owner of the auto rickshaw as a party.
Yes, sir. The petitioner has also failed to prove that he is rendered for compensation only appointed.
Who is the respondent? The injuries ಏನಾಗಿತ್ತು? R1. Sampath Bapat. ರಿಕವರಿ ಮಾಡ್ಕೊಳಕ್ಕಾಗತ್ತಾ ನಿಮ್ ಕೈಲಿ ಅವ್ರ ಹತ್ರ? ರಿಕವರಿ ಮಾಡಕ್ಕಾಗತ್ತಾ?
ಕಡಿಮೆ ಆಯ್ತು ಅಂತ ಒಪ್ಪಿಲ್ಲ ಅಂತ
ನೀವೆಷ್ಟು ಕೇಳಿದ್ರೆ? ಬಟ್ ಏನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ?
Also, the accounting revenue,
ಎಲ್ಲಿದೆ? There's no reference here. There's no reference here to any of that.
Because with
AM report ఏదో? ಇಂಪ್ಯಾಕ್ಟ್ ನಿಮ್ ಪ್ರಕಾರ ಹಿಂದೆಯಿಂದ ಆಯ್ತಾ ಹೆಡ್ ಆನ್ ಆಯ್ತಾ ಹೆಂಗಿದೆ? Who was driving the tractor? Was he examined? Did you make him a party? Medical evidence in ನಿಮ್ಮ ಪರ ರೆಸ್ಪಾಂಡ್ ಪರ ಯಾರಿದ್ರು? ವಿಟ್ನೆಸ್ ಯಾರು ಇಲ್ವಾ? ಅವ್ರು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಲ್ಲ? RW1, RW. Who's RW1 and RW2? She is not an eyewitness to the accident, isn't it? Who's RW2? Is a death also? Death ಆಗಿತ್ತ? ಅವ್ರದ್ದೇನ ಎಕ್ಸ್ಪ್ಲೇನ್? Driver of the tractor was not examined. Driver of the tractor was not examined. Because by the claimant, challenging the dismissal of his claim petition. So the case of the claimant that he was traveling in an auto rickshaw along with other passengers. And at about 7 p.m., when the auto rickshaw came near the crusher at Baichapura Cross, the auto collided with a tractor, and as a result of which the claimant, along with others, suffered serious injuries. The tribunal, the claim petition was filed only against the owner of the tractor. The owner denied the governments in the claim petition. It was contended by the owner that the tractor had not collided with the auto rickshaw at any point of time, and the auto rickshaw skidded on the edge of the tar road and fell in and fell down, and that was the only reason for the accident. In other words, the claim of the owner was that there was no impact at all between the tractor trailer and the auto rickshaw. The tribunal has found that the claimant did suffer injuries, and by applying the principle of preponderance of probabilities, the respondent being the owner of the tractor was vicariously liable. However, it has dismissed the claim petition on the ground that there was no conclusive proof regarding the occurrence of the accident. The IMB report produced as Exhibit T4 indicates extensive damage to the auto rickshaw. Only a scratch to the right side rear wheel tire to the tractor. The sketch which is produced as Exhibit T5 indicates the point of impact on the road, which was just about 14 feet wide. It is also not in dispute that a charge sheet was laid against the driver of the motor of the tractor. The claimant has also produced a wound certificate in which it is stated that the claimant was examined on 21/3/2011 at 7:45 p.m. That is on the very day of the accident. The wound certificate states that the claimant was unable to move right hand, and there was deformity to the right leg, which was immediately referred to. He was immediately referred to a higher hospital. The causal diagnosis indicated there is that the claimant suffered right side contiguia fracture, dislocation of right tibia shaft, distal 1/3. Since there is medical evidence recording the fact that an injury occurred, the claimant was examined at 7:45. So itself an indication of the fact that an accident did occur on 21st of March 2011. The claimant is also produced medical records indicating the course of treatment that she undertook at MS Samaya Hospital. This view of the matter, the finding of the tribunal that there was no accident cannot be accepted, and the same is accordingly set aside. As far as negligence is concerned, the claimant examined herself and she deposed. Well, Did you examine the driver? If you can examine the inmate of that auto to say that the accident occurred because of a glaring headlight from the tractor, do not have examined the tractor driver. The tractor driver was the best person to state whether an impact occurred or not. Why were you shielding the driver of the tractor? And there's a death also that occurred. Why did you not examine the tractor? You tell me that if you can procure the witness who was an inmate of the auto rickshaw to support your case, despite the fact that there was a death in the tractor and the tractor turned turtle, you cannot secure the presence of the auto rickshaw. If you can secure a presence of that person who was traveling in the auto rickshaw which turned turtle, could you not have secured the presence of your driver? Charge sheet is against the driver. I saw. Even according to your objections, the accident occurred. Have you seen your objections? This is a story that you set up. Para 23. The tractor trailer had not dashed to the auto at any point of time. The auto skidded at the edge of the tar road and that auto fell down was the only reason for the accident. So according to you, the auto went into a skid. And your client, your witness, the inmate, suggests that because of the glaring light from the tractor, he went off and he also put forward the plea that the auto driver was intoxicated. So is not your witness contradicting your own statement? When you filed the objections, you were only the owner. You had no idea about the occurrence of the accident. So you got a person who was traveling in the auto rickshaw. And he has said that because of glaring headlights, he lost control and went and fell into a ditch. And the tractor will have a glaring headlight. It does not have headlight in the first place at all, most of them. It's not like as if it's an LED. I will consider that. I will go by your own witness. I will consider. So also the charge sheet also has some evidentiary value. Your witness's evidence is the best evidence. Why do I require the IM report when I have your witness? So you have to discard your witness. IM report is. ಅಲ್ಲ ನಿಮ್ ವಿಟ್ನೆಸ್ ಹೇಳ್ತೀರಿ ಎದುರುಗಡೆ ಬರ್ತಿದ್ರು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಹೆಡ್ಲೈಟ್ ಜಾಸ್ತಿ ಆಗೋಯ್ತು ಅಂತ. And the evidence also indicates that there was a curve, something like that. The evidence. Tractor ಏನ್ ಸ್ಪೀಡ್ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಸಂಪತ್ ಸ್ಲೋಪ್ ಇದ್ದಾಗ ಏನ್ ಸ್ಲೋಪ್ ಅಲ್ಲಿ ಎಷ್ಟು ಸ್ಪೀಡ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಡುತ್ತೆ ಹೇಳಿ 14 ಅಡಿ ರೋಡ್ ಟ್ರ್ಯಾಕ್ಟರ್ ಅರ್ಧ ಜಾಗ ಹಿಡಿಯುತ್ತದೆ ಅದಕ್ಕೊಂದು ಟ್ರೇಲರ್ ಬೇರೆ ಇತ್ತು ಇಲ್ಲೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಎಕ್ಸಿಬಿಟ್ P4 So impact ಅಂತೂ ಆಗಿದೆ ಅಂತ ಆಗುತ್ತಾನೆ. ಬಟ್ ಹೆಂಗ್ ಬಂತ ಅಲ್ಲಿಗೆ ಸ್ಕ್ರಾಚ್? The weight of the tractor trailer, even touching an auto rickshaw, is enough to send it across. You are coming down in a slope, so obviously you will have some speed. So a small touch also from the auto rickshaw from the tractor with its weight will throw it off the road. This finding will hold the good there also. No, I've heard you now. When we came, I went through the entire paper. Since I thought there's an evidence on record to show that there's an accident, and your own witness says the tractor came from the opposite direction. It was good enough for me. ರಾಜಿ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಂತೆ. I will dispose it off. I will not sign it. If you report a settlement, I'll not sign the order. I'll accept this. And she has deposed that the accident occurred due to the negligence of the driver of the tractor on behalf of the owner of the vehicle. One of the inmates of the auto in which the claimant was traveling was examined as RW2. RW2 the RW2 in his examination in chief stated that since the auto fell into a ditch, it turned turtle, and the auto rickshaw driver immediately jumped out of the auto rickshaw and ran away. He also admits that injuries occurred to the claimant, and an inmate also died. Another inmate died. In the course of his cross-examination, the claimant states as follows. Thus, as could be seen from the said evidence, according to the inmate of the auto rickshaw, due to the glaring headlights of the oncoming tractor, the driver of the auto rickshaw lost control and drove the auto rickshaw into a ditch. It resulted in the injuries and also a death. Exhibit P4 is the sketch prepared by the police authorities indicating the manner in which the accident took place. The said sketch indicates that the width of the road was only 14 feet. Judicial notice can be taken of the fact that the headlight of a tractor, the illuminating factor of the headlights of a tractor can never be a ground, can never be considered as a cause for an oncoming driver to be dazzled and to lose control. It also have to be kept in mind that both the tractor as well as the auto rickshaw are not designed for traveling at excessive speeds. The fact that the witness of the owner himself admits that due to the oncoming tractor, the auto rickshaw driver lost control, establishes the fact that an accident did occur because of the oncoming tractor. Keeping this in mind, if the IMV report is examined, which indicates that there was a scratch on the right side of the rear wheel tire of a tractor, it will have to be assumed that there was an impact between the tractor and the auto rickshaw. It is to be stated here that the rear wheel of a tractor is a huge tire, and for a scratch to be found on the huge tire is indicative of the nature of impact that the tire had with the auto rickshaw. I am therefore of the view that a combined reading of the evidence as well as AMV report would only go to show that there was indeed an impact between the tractor and the auto rickshaw, which caused the accident, as a result of which the claimant suffered injuries. The finding of the tribunal to the contrary is therefore set aside. As far as compensation is concerned, the doctor who had deposed on behalf of the claimant was one of the doctors who treated the claimant at MS Ramaya Hospital. He has stated that the claimant had suffered 21.7% disability to the whole body. Since the deposition is by the treated doctor, the assessment of disability is required to be accepted, especially when it has been recorded that the claimant had suffered a fracture of the tibia, right leg, and a Montegia fracture, dislocation, right. The accident is of the year 2011. There is admittedly no evidence establishing the actual income of the claimant, and hence the income determined by KSLSA, which would be rupees 6,500, is adopted. Consequently, the claimant will be entitled to some rupees 6,500 into 12 by sexta. It's 17, huh?
13.
17 into 21%. The claimant was admitted to the MS Ramaya Hospital and on 2 occasions, and she also had to undergo a surgical procedure. That view of the matter, the claimant will be entitled to some more rupees 50,000 towards pain and suffering, and some more rupees 50,000 towards loss of amenities. Medical expense ಎಷ್ಟಾಗಿದೆ? ಒಂದೇ ಬಿಲ್ 23,000 ಇದೆ ನೀವು. ಒಂದೇ ಬಿಲ್ 23,000 ಇದೆ. ನಾವು ಟೋಟಲ್ ಮಾಡ್ಕೊಡಿ. The bills produced by the claimant indicate that the claimant had incurred some rupees so and so as medical expenses. Since there is documentary evidence to support this claim, the claimant is awarded some rupees so and so. The claimant was also admitted to the hospital on 2 occasions. It will therefore be appropriate to award some rupees 25,000 towards conveyance, food and nourishment. Consequently, the appeal is allowed to the extension. Give the figure. Your settlement adre, you tell me, I will not sign that. I will post it again. Srishayla avare.
Yes, my lord. I appear for respondent and I
In-
connected case appellant. The insurance
In-
company has filed appeal on the ground of liability.
Why are you not liable?
My lord, admittedly, the vehicle insured was a petrol tanker, hazardous goods. The driver I have examined, owner also contested. Admittedly, he had no driving license to drive hazardous goods and the date of the accident. As per the ruling of the division bench ruling of this honorable court, my lord, pay and recover ಆಗ್ಬೇಕಾಗತ್ತೆ.
Selva.
ಹೌದು, ಜಸ್ಟಿಸ್ ನಾಗರತ್ನ ಮತ್ತೆ ಹೊಸಮನೆ ಅವರ ರೂಲಿಂಗು 2020.
Amount ಕಮ್ಮಿ.
ಹೌದು.
ಅದ್ಯಾವ್ದು ರೂಲಿಂಗ್ ಯಾವ್ದು ಟ್ಯಾಂಕರ್ದು?
My lord, I will pass on the ruling, my lord. That is MFA 2482 of 2015, judgment dated 16/6/2020.
16/6/2020.
ಹೌದು, 2020.
MFA 2482 ಅಲ್ವಾ?
ಹೌದು. And one another ruling of previous ruling of this honorable court only, MFA 30081 of 2011, 30328 of 2011.
ಒಂದ್ ಸಾಕ್ ಬಿಡಿ.
ಹೌದು.
ಒಂದ್ ಸಾಕ್ ಅಲ್ವಾ? DB ತಾನೇ ಇದು?
ಹೌದೌದು, ಡಿವಿಷನ್ DB.
ಏನ್ ಕಮ್ಮಿ ಆಗಿದೆ? ಎಷ್ಟು? 5,000.
And one more contention I have taken is 2-wheeler ನಲ್ಲಿ 3 ಜನ ಹೋಗ್ತಾ ಇದ್ರು, ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇದೆ ಅಂತ ಒಂದು ತಗೊಂಡಿದ್ದೀನಿ.
ಏನ್ ಬರಲ್ಲ ಅಲ್ವಾ?
ಅಲ್ಲ, ಅದನ್ನ ಲಾರ್ಡ್ಶಿಪ್ ರೆಫರ್ ಇಟ್ ಅಂಡ್
ಏನ್ ರಿಕವರ್?
ಹೌದು.
7,000. ನೀನೇನು 25%. ಯಾರ್ಯಾರು ಕ್ಲೇಮೆಂಟ್ಸ್? ವೈಫು, ಸಣ್ಣ ಡಾಟರ್ಸ್. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಇದೆಯಾ? ಅಲ್ಲ, ಪೇ ಅಂಡ್ ರಿಕವರ್ ಅವ್ರು ಕೊಡ್ತಾರೆ ಬಿಡಿ.
ಪೇ ಅಂಡ್ ರಿಕವರ್ ಆಗಿದೆ. ಅದರಿಂದ
ಏನು ಖಾಲಿ ಇದ್ರು ನೀವು ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡ್ತೀರಾ? ನೀವು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಖಾಲಿ ಇತ್ತು ಅಂತ.
ಆ ತರದ್ದು ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ.
ಅದು ಹೇಳಿದ್ರೆ ನಾನು ಎಕ್ಸಾಮ್ ನೀವು ಹೇಳಿದ್ರೆ ಸುಮ್ಮನೆ ಇದ್ರೆ ವಾಟ್ ವಾಸ್ ಯುವರ್ ಡಿಫರೆನ್ಸ್?
ಎವಿಡೆನ್ಸ್ ಐ ಹ್ಯಾವ್ ಹೇಳಿಲ್ಲ. ನಾಟ್ even one sentence about it. We have examined the RTO also. Driver also has given evidence.
ಏನು ಹೇಳಿಲ್ಲ ನಾನು. This appeal MFA
And interest ಒಂದು 7.5% ಕೊಟ್ಟಿದ್ದಾರೆ, 6%.
1074/2016 is by the claimant. challenging award of the tribunal on the ground that the quantum of compensation awarded is inadequate, while MFA 4958/2015 is by the insurer challenging the liability hoisted on it. The fact that an accident occurred on 10/2/2012 between a petrol tanker and a two-wheeler is not in dispute. The fact that as a result of the accident, Malaya, the pillion rider, was killed is also not in dispute. The petrol tanker was insured with the
Appellant. National.
correspondent in MFA 1074/2016. The only contention advanced by the insurer is that the driver of the petrol tanker did not possess the requisite endorsement enabling him to drive.
Only contention ಬೇಡಿ ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಹೇಳಿದೀನಿ, ಇಂಟ್ರೆಸ್ಟ್ ಹೇಳಿದೀನಿ.
Principal contention that he was not able to drive because the principal contention advanced by the insurer is that the driver of the tanker did not possess the requisite endorsement enabling him to drive a petrol tanker and therefore it could not be made liable. It is also contended that the driver of the two-wheeler had also contributed to the accident and therefore the element of contributory negligence ought to have been attributed to the said rider. Lastly, it is submitted that the award of interest at 7.5% is on the higher side and cannot be sustained in the event this court were to apply the principle of pay and recover. It is stated here that the division bench of this court, MFA 3432/2015, disposed of on 16/6/2020, has held that in cases where the insurer pleads that the driver of the petrol tanker does not possess the requisite endorsement to drive a petrol tanker, the insurer is bound to pay the compensation and thereafter proceed to recover the same from the owner of the offending vehicle. That view of the matter. The appeal by the insurance company will have to be dismissed over with an observation that the insurer would be at liberty to recover the compensation from the owner of the vehicle after it has paid the compensation to the claimants. As far as compensation is concerned,
ಡಿಸ್ಮಿಸ್ಡ್ ಅನ್ನೋದು ಬೇಡ, ಡಿಸ್ಪೋಸ್ಡ್ ಆಗ್ಬೇಕು ಅಥವಾ ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್ ಆಗ್ಬೇಕು. ಇನ್ಶೂರ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲ ಆಗುತ್ತಲ್ಲ.
by affirming the award of the tribunal insofar as directing the insurer to pay the compensation, or with a modification that the insurer shall be entitled to recover the money from the owner of the offending vehicle after it has paid the compensation to the claimant. As far as compensation is concerned, the tribunal has awarded a sum of rupees 6,50,000 after determining the notional income at rupees 5,000. Since there is no documentary evidence to establish the income of the deceased, it would be appropriate to adopt the notional income determined by KSLSA, which for the year 2011, 2012 was rupees 7,000. The deceased, what's ಎಷ್ಟು?
48.
47 years. Multiplier of 13, huh? Multiplier ಎಷ್ಟು? 13 will have to be appraised. Age, we set some more rupees 7,000. Future prospects of 25% would have to be added. Since the deceased was aged 27 years.
ಆಮೇಲೆ 12 ಮಲ್ಟಿಪ್ಲೈಯರ್ ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
So the result in the monthly income of the deceased to be 8,750 for the purposes of computing the loss of the payments.
ಆಮೇಲೆ 12 ಬರುತ್ತೆ ಮಲ್ಟಿಪ್ಲೈಯರ್ 12 48 years.
And put the directed towards such function. And thus the deceased is the income of the deceased that will take an of 6,563 for the purpose of calculating the loss of. As a deceased was aged
48 years ಮೇಲೆ 12 ಬರುತ್ತೆ.
multiplier of 12.
ಹೌದು
12 into
12 ಸರಳ ವರ್ಮ 12. There are 13.
13.
Yeah. ಅಲ್ಲ as per R1 deceased Malaya was aged about 45 years. As the judgment inquest report age is 48 years, then multiply 12 would be applicable. 46 to 50 12
13 ತಾನೆ
ಅಲ್ಲ 12 ಅಂತ ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ ಸರಳ ವರ್ಮ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಳ ವರ್ಮ ಪ್ರಕಾರ 13 ತಾನೆ
46 to 50 12.
ನಮ್ಮ ಚಾರ್ಟ್ ಅಲ್ಲೂ 13 ಅಂತ ಬರ್ಕೊಂಡಿದೀವಿ. 46 to 50.
Probably
The claimants being the wife and children of the deceased, each of them will be entitled to some rupees 44,000 shorts of consortium. And they would also be entitled to further sum of rupees 33,000 for the convention rates. Plus 33,000 for the convention rates. Plus the claimants will be entitled to the said sanction carry interest expenses. Includes the deposit. The payments would however not be entitled to the delay for the interest for the delayed period of 187 days. 13.
ಆಗ್ಬೋದು.
That's when the appeal filed by the government is allowed in fact, and the appeal filed by the insurer is disposed of with a modification. Including the award.
Interest 6%.
6%. ಮಹೇಶ್ ಅವರೇ
With liberty to recover from the owner at perpetual.
ಮಾಡಿದ್ದೀನಿ.
Yes, my lord.
45.
Yes, my lord.
Valid driving license. Pen recover. Pen recover. Pen recover.
ಇದರಲ್ಲಿ 15 persons my lord were traveling in the tempo traveler. My lord, the charge sheet says my lord that the insured himself was driving the vehicle without a license. if it has been, my lord, some other person driving on behalf of the, my lord, owner insured, then, my lord, the question of, my lord, the vicarious liability, you will have to kindly see. Here, my lord, he himself, knowing fully well, was driving the, my lord, insured vehicle without license and tried to, my lord, say that somebody else was driving the vehicle. That has been disproved. Court has come to the conclusion that he has given a divergent evidence, and he himself was driving, and 15 persons were being carried in the tempo track.
He was himself driving. He was himself driving. Owner was driving. What is the finding of the tribunal? What was the vehicle?
Goods tempo, my lord, from para 21, kindly, my lord, 18, from para 18. Para 13, my lord, it would be relevant. The witnesses, my lord, who have spoken to about.
We'll finish this paragraph and then come there. Let him finish.
Yes.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ ಮಹೇಶ್ವರ್ ನೀವು?
Pardon?
ಅದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್?
Para 21, my lord, onward. But it will be, my lord, relevant to read para 14 to, my lord, 21. But 21 would be relevant for my purpose, my lord. May I read para 21, my lord? From the evidence of RW2, my lord, that the insured, it appears that according to the respondent number 1, at the time of the accident, he was not present and he was not driving the offending goods vehicle tempo. But he was hired this offending vehicle to Venkataramanappa for transporting of vegetables from one place to another place by engaging coolie and the driver separately. But the said contention taken by the respondent number 1 in his evidence are quite contrary to the contents of Exhibit P2 charge sheet. At this tribunal has already observed that neither the petitioner nor the respondents have challenged Exhibit P2 charge sheet before the Honorable Appellate Court. The respondent 1 who is the registered owner of the offending goods vehicle, has taken conflicting defense. He has not produced his driving license to substantiate at the time of accident he was an effective and valid driving license, and as such the investigating officer has not made allegation as against him about not having a valid and effective driving license under section 3 of the MU Act. Even the respondent number 1 did not care to examine the said Venkataramanappa as witness on his behalf to show that at the time of the accident another driver was engaged by the said Venkataramanappa for transporting of carrot through his goods tempo by engaging the petitioner as police. If the respondent number 1 has produced his valid effective driving license, the matter could have been different. And in that circumstances, the respondent number 2, insurance company having the valid exhibit R on insurance policy of the offending goods tempo is liable to pay the compensation to the petitioner, which is already decided by this tribunal. For the first time in his evidence, respondent number 1 has taken such defense, which is quite contrary to contents of exhibit P2 charge sheet and his written statement. The respondent 1 has utterly failed to plead and prove that at the time of the accident he had his offending vehicle to Sri Venkataramanappa, and he was not driving the offending goods vehicle at the time of the accident. But the driver who was engaged by the said Venkataramanappa was driving the offending goods vehicle at the time of the accident, and the said driver was having a valid effective driving license to drive the such class of vehicle at the time of the accident. From this, it is important to make crystal clear that the respondent 1, who is the registered owner cum driver of the offending goods vehicle bearing registration number so has violated the terms and conditions of the exhibit R1 insurance policy, wherein it is clearly mentioned so and so. But here you must kindly see, they try to malad that even as per the missing malad, these injured persons were not coolies under the malad owner insured. One Venkataramanappa has had, and he was having his own driver and for loading and unloading carried. But you have to kindly imagine 15 persons being carried, where there can be any space for the load. The entire claim is with contradictory evidence. So far as the liability is concerned, in any event, it may be observed that these persons were not the coolies of the owner insured. It was stated that it was Hayatu and Venkataramanappa. He has not been examined. Charge sheet is against the owner insured.
Owner ಯಾರು? ಹೆಸರೇನು owner ಹೆಸರು?
He was examined at RW2.
Please come to your objections, para 15 of your objections before the tribunal. Para 15, your insurance company says,
Yeah.
as much as in the absence of not being made the driver of the vehicle as a party to the above proceedings, as is a proper and necessary party in given case. So you are saying somebody else was driving even according to you.
But I invite your lordship attention to section 134C of the Motor Vehicles Act, where the owner
I will come to the legal
person
question
who is in
afterwards.
charge of Lord has to inform. And the
No,
police concerned, my lord, also duty bound under section 158(6), my lord, to inform. My lord, the statement, my lord, filed by the written statement of the, my lord, the insurance company cannot be, my lord, overlooked by the evidence, my lord, let in by the, my lord, the owner insured.
My understanding of the law is, if the insurer is able to take up the defense that the owner had acted negligently in entrusting the vehicle to somebody, if it is established also, even then you will have to go pay and recover. Here you are admitting in your objections that the driver is not made a party. Therefore, the implication is you are admitting that he was not driving the vehicle.
But a driver is not
So therefore-
made a part, driver not made a party doesn't mean, my lord, that whoever, my lord, is shown is thing. You have to kindly see, charge sheet, my lord, is against the, my lord, owner insured.
The charge sheet may be
That
against the
fact,
owner.
my lord, that fact, my lord, cannot be, my lord, ignored. And
So
evidence
can
of,
I
my
ignore
lord,
your objections where you said that somebody else was the driver?
so if, my lord, on the evidence of, my lord, the written statement, my lord, if the, my lord, then there is no reason for, my lord, any of the parties to the proceeding to read any evidence. Only on the pleadings it can be disposed of.
Maybe I didn't convey my, according to my understanding, insurance company is entitled to take a defense that the owner had committed a mistake in entrusting the vehicle to somebody who did not possess the license.
Now that you have to kindly see the evidence, specific evidence of, my lord, the owner insured is so. My lord, the defense taken by the
Does he
insurance
admit that he was driving the vehicle? Does the owner admit that he was driving the vehicle?
But that defense cannot be of any consequence because there was no compliance of section 134C by the owner insured. And you must kindly see, along with the claim petition, whether the documents were produced as required under say Rule 232, 323. Therefore, my lord, if any defense is taken that cannot be used against, my lord, in the light of the, my lord, the material evidence which is placed by the claimant and the owner of the vehicle.
Is there any evidence to show from these alleged coolies that the respondent was driving?
My lord, he himself said that it was hired to Venkatramanappa. They were his coolies, not his owner insured.
I'm on the question of driving. Who was driving? Do the coolies admit that respondent was
There, my lord, you also got it. The Venkatramanappa was having a driver of his own, but his name is not forthcoming. He had taken the vehicle on hire and he was having his own driver and he was, my lord, using it for transportation of, my lord, loading and unloading of the carriage. And 15%, can it be imagined, my lord, in a goods vehicle where a cabin, my lord, having a capacity, permitted capacity of only 1+1. 15% in the body, even rule 100 of the Karnataka motor vehicle rules, my lord, does not. Therefore, my lord, my respectful submission, this is how, my lord, the claims are being concocted to see that the insurance companies are made liable. And the tribunal, my lord, in the right perspective has come to the conclusion that the owner is liable under the circumstance of the.
Is there any evidence to show that the police stated that he was the driver?
And charge sheet has not been challenged either by the claimant or by the owner, my lord.
Because I do not know the name of the driver of the offended vehicle.
So even the suggestion of the insurance company is that somebody else was driving. That is a suggestion put by the insurance council also.
Okay. But
To the
the the fact remains, my lord, the charge sheet is that which is not being challenged by anyone.
Where is the charge sheet?
If the charge sheet goes, my lord, then everything goes. P2. Case of the Malad owner ensured that it was hired to Venkataramanappa and he was having his own driver and the persons carried were his coolies, not even his owner insured. Vicarious liability does not arise because it is not a case where somebody else was driving the insured vehicle.
ಏನಾಯ್ತು criminal case did he plead guilty? Because if he has pleaded guilty, that means he accepts that he was the driver. As he pleaded guilty, this Abraham, in the criminal case.
But that they have not placed any material, my lord. It is for them to prove. As I said, my lord, there is no complaints of section 134C and 158(6) by the investigating officer.
If you want me to rely upon the charge sheet, the charge sheet does not indicate that he was driving without a license.
But that he has not produced the driving license. You have to kindly see the two versions. But he said that Venkataramanappa has engaged a driver.
No, you want me to accept the charge sheet.
But only for the purpose, not that who was driving at the time of the accident. He has not produced his driving license.
Now, if I have to accept that the charge sheet indicated that Abraham was driving, I also have to accept the fact that the police had not charged him for not driving without a valid driving license.
But not charging, my lord, for not having a valid driving license, my lord, maybe for so many reasons, which I don't want to, my lord, disclose before your lordship. But the fact remains that the owner insured, my lord, has come up with two theories, contradictory. Because of that, my lord, the tribunal, after examining, my lord, the evidence and also the evidence of, my lord, RWT, the owner, has come to the conclusion he could have produced his driving license. He was examined.
So if it is this case that he was not driving, why should he produce his driving license?
Well, when there is a charge sheet against him, my lord, it is for him to, my lord, think.
Then I will accept the charge sheet as being the gospel truth, and because it's not charged.
My lord, he has not, my lord, challenged the charge sheet. He could have said, my lord, when he was examined as RW2, he said, I have a driving license. He could have proved it. Not producing the driving license, my lord, presume that he was not.
ಇದೆಲ್ಲ ಸರಿ ಇದೆಯಾ 45 ಪಾಯಿಂಟ್ ಏನಾಗಿದೆ ಅದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ ಆಫ್ ಡಿಸಬಿಲಿಟಿ ಏನು the whole body 45.2 na page number ಏನು finding regarding the injury so the earlier compensation is confirmed. But you had not challenged the earlier order. The earlier order, correct, the insurer filed an appeal. You did not. Now, because the insurance company is exonerated, you are an appeal. In the first round. What is your MFA number? MFA number. They'll refer Madilla. Order page number 11. Correct, but usually findings on liability at page number 11, they only refer to the appeals filed by the insurer. 9263, 9262, 9264, 9265, and 9266. There is no appeal of the claimants for enhancement. If you have accepted the first order regarding the award, and only they were agreed by the fixing of liability. Today, order code MF 90. The appeal was also by you only, by all the claimants. In that view of the matter, the impugned judgment settling liability of the owner of the vehicle is set aside, and to that extent, the matter is remitted. The compensation is only to that extent was remitted to consider liability. Therefore, another ಜಾಸ್ತಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. These appeals been filed by the claimants challenging the award of the tribunal, by which the tribunal.
But one more point to be considered by Lordship is not loose tempo. Even if rule 100 or to be applied, my lord, it will not be, my lord, so far as, my lord, so many people being carried in the, my lord, goods vehicle contrary to the province of law. Therefore, my lord, even if you want to, it has to be restricted to, my lord, the carrying capacity.
You can always recover it from the owner, isn't it? That's what I'm granting you liberty. You will not lose anything. You will recover from the owner.
Recovering from the owner is different. My respectful submission, my lord. In law, even rule 100 of the motor vehicle rules to be applied, my lord, it will not exceed. Therefore, my liability, my lord,
Supreme Court has said that even if he has no license, you have to pay and recover. That is also against the law. Driving without a driving license.
I am not on that aspect, my lord. I am on the aspect of number of the claims in which, my lord, I am liable for pay and recover.
The ultimate intention, according to my understanding, is that the victim should not suffer. Liberty is given to you, you can always recover. You can always have the resources to go against the
owner. To recover is different, my lord. Whether I am liable, if I am liable to how many claims?
No, I am going to hold that.
I am only, my lord, asking the court to, my lord, restrict my liability even for pay and recovery to the number of, my lord, claims under the rule 100.
Some related the liability of insurance. Very important. On an earlier occasion, the tribunal had passed an award, and even in its earlier award, the insurance company was absolved of the liability to pay compensation.
That award was challenged by the claimants MFA 9263 2008 and connected matters. This court by an order dated 14th of July 2014 disposed of the appeals in the following terms. Para 6. Thus, the matter was remanded to tribunal to consider whether the insurer had taken the appropriate stand and also proved the said stand taken so as to exonerate itself of its liability, and also to examine whether there was any breach of condition as per section 147 and section 149 of the Motor Vehicles Act. The counsel for the claimants contended that it was the case of the insurer that the vehicle was being driven by a person who did not possess the valid license. And in fact, the specific attention taken by the insurer was that the driver had not been made a party. Since the ultimate analysis, the argument, the contention advanced by the insurer was that there was a breach of the policy conditions. The right of the judgment of the full, right of the judgment of the full court, the 11th, the principle of pay and recovery would have to be adopted. The O Mahesh, that concept for the insurer, on the other hand, contended that this was a case in which the goods vehicle was carrying 15 people, and this by itself indicates that there was a gross violation of the provisions of the Motor Vehicles Act. And in that view of the matter, the insurer could never be made liable. He also sought to contend that as per the charge sheet, the owner of the vehicle was himself driving the goods vehicle. That the vehicle had been entrusted to a person who did not possess the requisite valid license stood automatically proved. In other words, it was this contention. Since it was the owner who was found to be driving the vehicle, and he was obviously aware
Court audio is muted, Mala. Court audio is muted, Mala. for your own.
just come. You bag like
ಎಕ್ಸಾಮ್ ಡ್ರೈವರ್ ಎಕ್ಸಾಮ್ ಮಾಡ್ಲಿ ನೀವು ಮಾಡ್ಬೇಕಿತ್ತಾನೆ. ಆದ್ರೂ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಅದನ್ನ ಹೇಳ್ಬೇಕು ತಾನೆ ಡ್ರೈವರ್ ಹೇಳ್ಬೇಕು ತಾನೆ. ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ರು? ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಲ್ಲ. ಒಂದೇನು ತಪ್ಪಿಲ್ಲ ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಬೇಕಿತ್ತಾನೆ. ಇಸ್ ಅ ಪ್ರೊಫೆಷನಲ್ ಡ್ರೈವರ್. ಅಂದ್ರೆ ಆ ವರ್ಷ ಒಪ್ಕೊಳ್ತೀನಿ, ಸಡನ್ ನಿಲ್ಸ್ಬಿಟ್ರೆ ಅಂತ ಒಪ್ಕೊಳ್ತೀನಿ. ಅದು ಮಾತ್ರ ಬೇಡ ಅಂತೀರಾ? ನೀವು ಅದನ್ನ ಡಿನೇ ಮಾಡ್ತಿಲ್ವಲ್ಲ. ಫ್ಯಾಕ್ಟರಿ ಸರ್ಕಲ್ ಕೇಸ್ ತಾನೆ ಪ್ರದೀಪ್. ಒಳ್ಳೆದು. ಒಂದೇ ಒಂದು ನನ್ನ ಪ್ರಕಾರ ಅವ್ರು ಡ್ರೈವರ್ ಎಕ್ಸಾಮ್ ಮಾಡಿಲ್ಲ, ಒಂದೇ ಪಾಯಿಂಟ್. ಬಟ್ ಅದಕ್ಕೆ ಗಾಡಿಗೆ ಒಂಚೂರು ಡ್ಯಾಮೇಜ್ ಆಗಿಲ್ಲ. ಇಲ್ಲ ಏನು there were no ಇಲ್ಲ ಅವ್ರಿಗೆ there were no any fresh visible damages found when I inspected the vehicle. So sudden stop ಆಗಿ ಹೋಗಿ ಹೊಡೆದ್ರೆ ಏನೋ ಸ್ವಲ್ಪ ಡ್ಯಾಮೇಜ್ ಆಗ್ಬೇಕಂದ್ರೆ ಅದಕ್ಕೆ ಏನೂ ಆಗಿಲ್ಲ. ಪ್ರಿಸಂಪ್ಷನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ತೋರಿಸಿ ಸಜೆಷನ್ ನೋಡೋಣ, ಮೊದಲೇ ಸಿಗುತ್ತೆ ನಮ್ಗೆ. ಇಲ್ಲೇನ್ ರೇಟ್ PW2 ಮೋಹನ್ ಮೋಟರ್ ಬೈಕ್ ಚಾಲಕ ತಪ್ಪಾಗಿ ಮೋಟರ್ ಬೈಕ್ ಅನ್ನು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ತಾನೇ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಲಾರಿಗೆ ಡಿಕ್ಕಿ But the driver is not examined. ಅಲ್ಲ ನೀವು ಅದನ್ನ ಹೇಳ್ಬೇಕು ತಾನೆ, ಅವ್ನು ಬಂದ್ಬಿಟ್ಟು ಅವ್ನು ತುಂಬಾ ಜೋರಾಗಿ ಬರ್ತಿದ್ದ, ಮನೇಲಿ ಬ್ರೇಕ್ ಹಾಕ್ಲಿಲ್ಲ. ಅಲ್ಲ ನೀವು in a highway, even if the motorcycle is traveling at 70 kilometers per hour, your vehicle is also moving. So if you go hit a moving lorry, na correct ಹೋಗ್ತಾರೆ, but ಆ ಗಾಡಿ ಲಾರಿನ ಮುಂದೆ ಜೋರಾಗಿ ಹೋಗ್ತಾ ಇದ್ರೆ ನಮ್ಮ ಸಿಟಿಯಲ್ಲಿ, but highway ಅಲ್ಲಿ lorry is traveling at, let us say, 50 kilometers. For him to come and hit the lorry at 60 and fall down. Even if you keep a sufficient distance in a highway, if you suddenly stop, there's no way that you can avoid the collision. So you should have, the driver should have stepped into the box and said that he was traveling very close to me, and he came and ಏನು evidence ಇಲ್ಲ ಅಂದ್ರೆ why should I accept charge sheet is laid against you? ಅವ್ರ ಮೇಲೆ ಹಾಕಿದಾನೆ 80-20 20% ಕಮ್ಮಿ ಮಾಡ್ತೀವಿ, 75-25 ಅಂತ ಹೇಳಿದ್ರೆ 5% ಜಾಸ್ತಿ ಮಾಡ್ತೀವಿ. ಧನ್ಯವಾದ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನ್ ಕೆಲಸ? ಎಕ್ಸಿಬಿಟ್ ಯಾವುದು? ಪೇ ಸ್ಲಿಪ್. Tata Power, why should I display this? Tata Power, why should I? Cash talwala hai. $10,080 ಪ್ಲಸ್ ಎಷ್ಟು? ವಯಸ್ಸು ಎಷ್ಟು? 31. ಎಷ್ಟು ವರ್ಷ ಅಂದ್ರೆ 40%? ಕೊಟ್ಟಿದಾರ? ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 10,000 ಮಾಡೋಕೆ. This appeal is with the payment, challenging the award insofar as it attributes 40% negligence to the deceased, and also on the ground that the compensation awarded is inadequate. In this case, the fact that an accident occurred, as a result of which the husband of the first claimant was killed is not in dispute. It is also not in dispute that the chassis lorry, the chassis lorry, which was arrayed as respondent, was insured. It's also not in dispute. The tribunal, as on assessment of the evidence, come to the conclusion that the deceased was responsible for the accident to the extent of 40%. And the basis for this finding is that a charge sheet had been laid against both the driver of the lorry and the deceased. It is not in dispute that the accident occurred on a national highway. And this accident occurred when the rider of the motorcycle hit the chassis lorry from behind. In my view, having regarded the fact that the offending vehicle was a chassis lorry and did not, and obviously the chassis lorry did not contain the taillights as can be found in a regular lorry. It is quite possible that the sudden stoppage of the lorry or even the slowing down of the lorry would not have been noticed by the two-wheeler coming from behind. In any view of the matter, the apportionment of 40% negligence on the radar of the deceased is rather harsh, since it is quite possible that the driver of the chassis lorry had slowed down the vehicle for some reason. Since the driver of the chassis lorry has not been examined, in my view, it would be appropriate to modify the negligence, portion of negligence, to the ratio of 20/80 as against email 60 hakidra, our mail 60 as against 46 in favor of the deceased. The tribunal has determined the monthly income of the deceased at rupees 8,000. 8,000. ಯಾವ ವರ್ಷದ ಆಕ್ಸಿಡೆಂಟ್ ಅದು? ಸ್ಯಾಲರಿ ಯಾವ ವರ್ಷದ? ಅವಾಗಲೇ 8,500 ಇತ್ತು. ಅವಾಗಲೇ ಚಾರ್ಟ್ ಪ್ರಕಾರ 8,500 ಇತ್ತು. ಮಾಡಿಫೈ ಮಾಡಿ ಎಷ್ಟು ಬರುತ್ತೆ? ಇಲ್ಲ, ಎಷ್ಟು ಬರುತ್ತೋ ಅಷ್ಟೇ ಬರುತ್ತೆ. The counsel for the claimant contends that the deceased was earning a sum of rupees 10,080, and this was established by the production of a letter of the employer and also a pay slip, which indicated that the deceased was drawing a gross salary of rupees 10,080. ಏನಾಗಿ ಬರ್ತಿದೆ ಅಂತ ಹೇಳ್ತೇನೆ. The perusal of the payslip does indicate that the total earnings of the petitioner, the deceased, was rupees 10,080, and the payslip also indicates the sum of rupees 150 was deducted towards provisional tax. Therefore, it would be appropriate to to take the income of the deceased at rupees 9,800. 9,800. They said some 40%, out of which the claimant, say 1/3 or 1/4. 1/3 would have directed towards the claimants being the wife, son, and mother. Each of them were entitled to 44,000, 33,000. Thus, in modification of the award, the claimant will be entitled to the following sums. Since it is held that the claimant had contributed to the extent of 20%, the claimants will be entitled to claimants will be entitled to 80% of the whole sum, that is rupees 7. Interest at 6%. 33,000 ಅಷ್ಟೇ ಕೊಡೋದು. 33,000 and please accordingly. Counsel for the respondent here. Counsel for the appellant writes a memo stating that the matter was settled between the appellant dash owner and the claimant before the tribunal for a sum of rupees 5,06,000. Along with the memo, certified copy of the order sheet is also enclosed, which indicates that the sum of rupees 5,06,000 was paid to the claimants. In view of the settlement arrived at, the appeal would not survive for consideration. And it is held that the claimant's liability to pay compensation has been settled as per the decision in the Lok Adalat held on 30th of September 2021. It is therefore disposed of unnecessary. The amount in deposit will be refunded to the appellant.
But serial number 45.
9.
Court audio was muted, my lord.
49.
ಅಲ್ಲ 45 ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಮ್ಯೂಟ್ ಆಗಿತ್ತು.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಲ್ಲ, ಪೇ ಅಂಡ್ ರಿಕವರ್.
49, I am, my lord, appellant in 3 matters, my lord.
In case of?
But it's a case of, my lord, the
appeal ಇದೆ.
ಹೌದು, ನಮ್ಮ ಅಪೀಲ್ ಇದೆ, ಅವರ ಅಪೀಲ್ ಇದೆ.
ಆರ್ ಅಪೀಲ್ ನಿಮ್ದಾ? 6 ಅಪೀಲ್ ನಿಮ್ದು, 2 ಅಪೀಲ್ ಅವ್ರದ್ದು.
ಹೌದು.
ಏನ್ ಕಂಟೆನ್ಷನ್ ಏನು?
It is the averments of the, my lord, the claimant that they were traveling in an auto, 8 of them, and the insured motorcycle came from the opposite direction and dashed in mistake and made the auto to topple on the right side, and it was in the middle of the road. But my respectful submission, considering, my lord, the weight of the auto and the 8% being carried in the auto admittedly, can a motorcycle, my lord, even if it dashes against the auto rickshaw, can make it topple on the right side?
The accident is admitted. You're only saying that you are.
Accident is admitted, involvement, my lord, is that They say that motorcycle is involved, but the fact, my lord, the insured auto, the auto was not insured and the driver was not having driving license. For that reason, my lord, a theory was developed that the insured motorcycle dashed against the auto in which, my lord, 8 persons were being carried and made it to topple on its right side. Whether it could be possible, probable, and the probabilities.
What is the tribunal said?
The tribunal.
What is the tribunal recorded?
Yeah. Regarding that, my lord, you have to kindly ink page, my lord, 25. It goes, my lord, the charge sheet is filed against the, my lord, rider of the motorcycle. Therefore, my lord, the negligence, my lord, is proved. Number
Is
paragraph.
the only count?
Paragraph 24, my lord. The petitioner in all 4 cases contended that on 17/9/2013 at about 1:30 p.m. near the Kandalahalli, when all these petitioners were proceeding in passenger auto rickshaw bearing number so and so, from so and so, one Rudresh was driving the auto rickshaw slowly and cautiously on the left side of the road from Elandur towards Santenahalli near Kandehalli bus stand, and in the meantime a motorcycle Hero Honda Splendor plus bearing registration number so and so came from opposite direction, that is from Santenahalli side, in a rash and negligent manner and dashed against the passenger auto bearing registration number so and so. As a result of the same, said auto rickshaw turtled down towards right side of the road. And all these petitioners sustained injuries and they were immediately taken to government hospital so and so. Then, my lord, para 25. In order to prove the rash and negligent act on the part of the rider of the motorcycle, the petitioner number 2 in MEC number 133 of 2014 and petitioner in MEC 138 of 2014 and petitioner in MEC 140 of 2000 and that 131 of 2000 have been examined respectively as PW 1 to 4. They have reiterated in their affidavit that they were proceeding in passenger auto bearing registration number KA2 AD 2559 on 17/9/2013 at about 1 p.m. near Kandanahalli bus stand from Chengannahalli towards Talanur on Elandur Santenahalli road. One motorcycle bearing registration number KS1 came from opposite direction from Santenahalli side also. Then, my lord, he admits in his cross-examination that totally there were 8 passengers in the auto rickshaw and one Rudresh was driving. That means, my lord, 9 persons in the auto rickshaw. Then, my lord, para 26. The reasoning of the tribunal on the issue of negligence. The petitioners have produced police records also. Exhibit P1 FIR and Exhibit P2 is the spot master. Exhibit P1 clearly reveals that the case registered against the rider of the motorcycle bearing registration number so and so. The petitioners have produced the spot mahazar at Exhibit P2, which clearly reveals that the accident occurred near Kundanahalli bus stand, where there is another road which leads towards Naikara Bedi of Kandanahalli. And Exhibit P2 further reveals that the road was running east to west and the road was about 20 feet in width and accident occurred in middle of the road. The petitioners have also produced IME report, Exhibit P3, which reveals that the front of the both indicator assembly, front left hand side of body, complete glass post, front both side quarter glasses, upper frame and top hood of the auto rickshaw were damaged. Exhibit P3 also reveals that the headlight and visor and front right side indicator, clutch lever, front registration number plate, front left hand side foot rest of the motorcycle were damaged. Perusal of this exhibit P3 clearly reveals that the head-on collision has taken place between these two vehicles and accident occurred in the middle of the road. The petitioners have also produced the charge sheet, exhibit P6, which clearly reveals that the case was registered against the rider of the motorcycle, Mr. Vishwanath, son of Ramanakaya, that is rider of the motorcycle bearing registration number. The rider of the motorcycle would have been the best witness to depose with regard to composite negligence of the driver of the auto rickshaw. No doubt, it has come in the evidence that totally 8 persons were traveling in the auto rickshaw. It was overcrowded, but charge sheet was submitted against the rider of the motorcycle alone. The version of PW 1 to 4 coupled with the contents of exhibit P1 to 3 and 6 clearly go to show that the accident occurred due to the negligence, actionable negligence of the rider of the motorcycle bearing number so on. So accordingly, that's how Malad the tribunal proceeds. Part catch Malad is not produced. It is highly, my lord, improbable. If even in my lord, content, my lord, probability, a motorcycle dashing against an auto carrying, my lord, 9% to make it top. Not, my lord,
Are you arguing negligence or what is your point that you're trying to make?
Lord, it's on the question of negligence also.
Accident did not occur. Is that the argument?
Well, what I'm contending before Lordship is that the auto rickshaw had no license, insurance cover, and driver had no license. It was overloaded, and in order to, my lord, make a claim, they said that motorcycle rider came and dashed and made the auto rickshaw to topple. Whether this could be believed?
Is it your case that there was no accident at all? Is that the case?
Pardon?
Because what is your stand? What is your stand that there was no accident caused by the motorcycle? Is that the contention?
Lord, my respectful submission, my lord, it is due to the negligence of the, my lord, the driver of the auto. Even if the motorcycle, my lord, had dashed against the auto, it would not, my lord, make even to, my lord, to move back an inch with 9% in the auto. Since, my lord, the auto didn't have an insurance and driver had no policy, the rider of the motorcycle, my lord, has been and PW1, my lord, Madesh, who is examined, my lord, in MEC 133 of 14, my lord, admits that there were 8 passengers in auto.
The owner of the motorcycle did not
probability.
contest the matter. Owner of the motorcycle. Or Bandra expert in our. He did not file any objections.
But he was placed ex parte. Vishwanath, my lord, was placed ex parte.
Is a lawyer ಇಟ್ಟಿದ್ರಂತೆ.
Pardon?
Vishwanath.
As per the record,
He was represented some Santosh Kumar. In one case, I think he was placed ex parte. 1, 2 cases, but in MBC, the
No
MBC
statement, my lord.
132.
Yes, no statement, my lord, in other cases. That is as well as, my lord, that they wanted to see that the liability is fastened on the insurance company somehow. Probability, improbability, my lord, as the preponderance, my lord, would show that a motorcycle, a light vehicle, dashing against, my lord, 9 persons carried in an auto, making it topple, my lord, is impossible unless the driver of the auto himself was negligent.
The rider of the motorcycle did not examine himself.
Pardon?
Rider of the motorcycle was not examined.
But he is colluding with the, my lord, the claimant. How can it be, my lord, thing? From the records, my lord, you could lordship kindly see. Though he appears in few cases, no statement is filed. And in other case, my lord, he was placed ex parte. And he does not, my lord, even enter the witness box to say, give evidence. It's a clear collusion between the, my lord, claimant and the, my lord, insured rider.
Compensation ಯಾವ್ದು ಕಮ್ಮಿ ಆಗಿದೆ? ಮಿಕ್ಕಿದೆಲ್ಲ ಸರಿ ಇದೆಯಾ?
Come at 2:30.
2:30 I'll continue
Please.
this matter. Other
Please.
matters I'll repeat next week. The other primary is
But 62 is there, my lord. 62. That is yesterday's, my lord.
2:30 ಇದಾದ್ಮೇಲೆ ತಗೊಳ್ತೀನಿ.
Please.
At 2:30 I'll take it up after I finish this matter of yours.
Please, please.
But next week ಅಂತ ಹೇಳಿದ ನಾನು ಮಿಕ್ಕಿದಲ್ಲ except serial number 62 everything will be repeated next week.
ಪುಣಚ ಎಲ್ಲಿದ್ದೀರಾ?
ನಿಮ್ಮ ಪಕ್ಕದಲ್ಲೇ ಇದ್ದೀನಿ ಆಸ್ಟ್ರೇಲಿಯಾದಲ್ಲಿ.
ಇನ್ನು ಎಷ್ಟು ದಿವಸ?
I'll be back on the 6th. Another 2 more days.
ಓಕೆ.
ಹೇಗಿದ್ದೀರಾ?
ತುಂಬಾ ಕೋಲ್ಡ್ ಅಂತಾರೆ.
ಅಯ್ಯೋ ಸಾಕಾಗ್ಬಿಡ್ತು.
ಇಲ್ಲಿ ಮಳೆ ದಿವಸ ರಾತ್ರಿ ಮಳೆ ಬರುತ್ತೆ.
ನಮ್ಮ ಊರಲ್ಲಿ ಅಷ್ಟೇ ಕಾಣ್ತದೆ, ಕರೆಂಟ್ ಎಲ್ಲ ಕಾಣ್ತದೆ 3-4 days ಇಂದ.
ಅಲ್ಲಮ್ಮ ಇದು ಕೂರ್ಗಲ್ಲಿ ಅಂತೂ ಸಿಕ್ಕಾಪಟ್ಟೆ ಮಳೆ.
ಓಹೋ.
ಅಲ್ಲಿ
ಕರೆಂಟ್ ಇಲ್ಲ.
ಕರೆಂಟ್ ಏನಾಗಿದೆ, ನಿಮ್ಮ ಏರಿಯಾದಲ್ಲಿ ಏನಾಗಿದೆಯೋ ಗೊತ್ತಿಲ್ಲ.
ಟೂ ಮಚ್. ಬೆಂಗಳೂರಿಗೆ ಈ ಸಲ ತುಂಬಾ ಮಳೆ ಅಲ್ಲ.
ನ್ಯೂಸ್ ಏನಿಲ್ವಾ ನಿಮ್ ಊರಿಂದ?
ಅದೇ ಮಳೆ ಅಂತ ಹೇಳಿದ್ರು. ಕೆಲಸ ಮಾಡೋರು ಮಾಡ್ತಾ ಇದ್ರಂತೆ. ಮತ್ತೆ how is your son?
He is fine. He is coming in December. ಅಲ್ಲಿ ವಿಪರೀತ ಶೆಕೆ ಅಂತೆ ಅಲ್ಲಿ.
ಓ ಅದೇ ಯುರೋಪ್ ಅಲ್ಲಿ ಫಾರೆಸ್ಟ್ ಫೈರ್ ಎಲ್ಲ ಆಗ್ತಾ ಇದೆಯಲ್ಲ.
38-40 degrees.
ನಮ್ಮ ಕೋರ್ಟ್ ಇನ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ಲಿಲ್ಲಲ್ಲ, ಇದು ಶುರು ಆಗ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಯುಕೆನಲ್ಲೂ ಅಷ್ಟೇ ಅಂತೆ 40 ಇದೆ ಅಂತ.
ಹೌದೌದು, ಬಹಳ ಡೇಂಜರಸ್ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಎಷ್ಟನೇದು ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರು?
1, ಲಿಸ್ಟ್ ನಂಬರ್ 2.
ಲಿಸ್ಟ್ ನಮ್ದು ಲಿಸ್ಟ್ 2 ನಲ್ಲೇ ಇದೆ, ಒಂದು ಬ್ಯಾಚ್ ಇದೆ.
ಎಷ್ಟನೇ ಮ್ಯಾಟರ್ ನಿಮ್ದು?
ನಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಅಲ್ಲಿ ಒಂದು 7 ಇದೆ ಬ್ಯಾಚು.
ಓ
ಅದೇನ್
ಅಲ್ಲಿವರೆಗೆ ಬರ್ಲಿಕ್ಕಿಲ್ಲ ಅಲ್ಲ, 2011 ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ ಅವ್ರ ಮುಂದೆ ಎಲ್ಲ. ಈಸ್ ವೆರಿ ಶಾರ್ಟ್ ಅಂಡ್ ಸ್ವೀಟ್.
better to get disposed.
Insurance company is concerned.
ಮತ್ತೆ
ಬನ್ನಿ, ಬಂದಾಗ ನೋಡುವ ಬೆಂಗಳೂರಿಗೆ.
I'll be back on that is Monday or Tuesday.
We'll meet sometime. Okay.
Yeah, I'll call you immediately after getting back. Okay.
Okay, thank you.
Bye.
ನೋಡ್ರಿ ಒಂದ್ ನಿಮಿಷ ರೀಚ್ ಆಗುತ್ತೆ ಆಗಲ್ವಾ? ಏನ್ ಡ್ಯಾಮೇಜ್ ಏನ್ ಮಾಡಲ್ಲ ಇವತ್ತು ನೀವು ಇಲ್ಲಾಂದ್ರೆ 2013 ತಾನೆ ನೋಡ್ರಿ.
Serial number 26.
Number
Serial.
ನೋಡ್ತೀನಿ, let us see, wait. What is the matter about? Wait.
Serial number 26 next week. So my papers illa. I have to collect it from a friend. Counsel appearing for the appellant. Internet allu siglilla.
Mahesh? Yes. Injury ಏನು ಹೇಳಿದ್ರು?
ಇದು ಡೆತ್ ಕೇಸ್ ಅಲ್ಲಿ ಏನು ಎಷ್ಟು ಹೋಗ್ಬೇಕು? 8,000. Multiplier 13, 14 ಈಗ 75-24 ಇಂಜುರಿನ ಯಾವ್ದು ಕಮ್ಮಿ ಆಗಿದೆ ಅಂದ್ರೆ clavicle fracture 75-24. What's it? Yesterday ಅವ್ರದ್ದು 75-24. ಡಾಕ್ಟರ್ ಅವ್ರ ಹತ್ರ ಹೇಳ್ರಿ. PWP
ಫಲಭುಜದ ರಚನೆಯ ಪದರದ ಶಕ್ತಿ ಏನಿದೆ? ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಂತ ಕಾಣ್ತದೆ. 25%. Is 55 years old. 55 ಅಂತ ಬರ್ತೀವಿ. ಡಾಕ್ಟರ್ 55 ಅಂತ ಹೇಳಿದ್ರು. This is MFA 25-24 ಅಲ್ವಾ? ಸಂಬಳ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 8,000 ತಗೋಬೇಕಾ? ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 9,000. Pain and suffering? So loss of amenities and conveyance will increase. ಮಿಕ್ಕಿದೆಲ್ಲ ಸರಿ ಇದೆಯಾ? ಮಿಕ್ಕಿದೆಲ್ಲ 25% ತಗೊಳ್ತೀನಿ ಸರ್. ಇದು ನೆಕ್ಸ್ಟ್ four claim petitions alva? 4 claim petitions filed with the tribunal. ನಾಲ್ಕೆ ಇದೆ ಅಲ್ಲ, ಒಟ್ಟು ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ಸ್ ಯಾವ್ದು? 4 ಅಲ್ವಾ ಫೈಲ್ ಕೊಟ್ಟು ಟ್ರೈಬ್ಯುನಲ್ ಅಲ್ಲಿ? 131, 133, 138. ಅದ್ಯಾವ್ದ್ರಲ್ಲಿದೆ? But there are 2 separate judgments, and all of them are before me. Company appeal. The MVC 131, 133. ಇದು ಅದರದೇ ಬೇರೆ ಕೊಡಿ. MVC 132, 141, 430. MVC 132, 141, 430. 132, 141, 430. 132 ಇಲ್ಲ 141 ಇಲ್ಲ 400. Altogether 7 claim petitions. On 17/9/2013, an accident occurred between two-wheeler and an auto rickshaw, resulting in the death of one person and injuries to 6 other persons who were traveling in the auto rickshaw. As a consequence, claim petitions were filed for compensation against the rider of the two-wheeler and its insurer and his insurer. The tribunal, on a consideration of the evidence adduced before it, came to the conclusion that an accident did occur, and this accident was as a result of the negligence on the part of the rider of the two-wheeler. The tribunal thereafter assessed and awarded varying sums as compensation to the claimants. The insurer is an appeal. ಬರೀ 5 ಅಪೀಲ್ ಹಾಕಿದಾರೆ ಅವರು. ಇನ್ನೆರಡು ಅಪೀಲ್
7 ಮರು.
ಬರೀ 5 ಅಪೀಲ್ ಇದೆಯಲ್ಲ ಮಹೇಶ್ ಅವರೇ?
ಇಲ್ಲ 6 ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 49 MFA 8649 by the company.
ಯಾವ್ದು ಹಾಕ್ಲಿಲ್ಲ ನೀವು?
8650 ಮಲೋಡ್ 8651.
ಒಂದ್ರಲ್ಲಿ ಹಂಗಾರೆ 7ರಲ್ಲಿ ಒಂದು ಹಾಕ್ಲಿಲ್ವಾ? You must have filed 7 appeals ಅಂತ ಅನ್ಕೊಂಡೆ. In respect of some award you have not passed an appeal. You have not preferred an appeal.
ಅಲ್ಲ ಅದು ಅಪೀಲ್ ಹಾಕಿರ್ಬೇಕು ಒಂದು ನಿಮಿಷ.
ಇರೋದು 49.
ಅಲ್ಲ ಇನ್ನೊಂದು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ.
ನಂಬರ್ ಕೊಡ್ತೀರಾ?
I'll give my appeal number, Lord. 8649 50 51 52 53 54 and 55.
As a result, the insurer has preferred 7 appeals and 2 claimants have also filed appeal seeking for enhancement. The main contention advanced by the learned counsel of the insurer, Shri O. Mahesh, is that the case put forth by the claimants was unbelievable. He submitted that it is inconceivable that a motorcycle would have collided with an auto rickshaw, which was carrying about 9 people, and caused it to turtle. He submitted that the entire case put forth by the claimants ought to have been rejected in its entirety, and the claim petitions ought to have been dismissed. The learned counsel also submitted when the collision did take place, it will have to be held that the driver of the auto rickshaw was also responsible, and negligence ought to have been attributed on him, and consequently the compensation had to be reduced to that extent. The learned counsel submitted that the driver of the auto rickshaw and the owner of the auto rickshaw was deliberately not made a party, since the driver did not possess a driving license and the auto rickshaw was not insured. ಅಷ್ಟೇ ಅಲ್ವಾ?
And one more thing, probability and thing, not a lighter mass dashing against
it is inconceivable ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ.
mass velocity and this thing,
that's what I said, it is inconceivable. Learned counsel for the claimants on the other hand
contended that the findings recorded by the tribunal regarding the negligence of the rider of the motorcycle cannot be doubted, especially when a charge sheet had been laid against the rider of the motorcycle and the owner who had entered appearance in one of the claim petitions had chosen not to contest the proceedings. He submitted that the evidence of all the claimants was consistent and clearly established that the accident was only on account of negligence of the rider of the motorcycle. The IMB report that was produced as annexure as exhibit P4 indicates that the motorcycle suffered the following damages. And the auto rickshaw suffered the following damages. A perusal of the accidents, the damages caused to the motorcycle clearly indicates that the accident occurred as a result of an head-on collision between the rider of the motorcycle and the auto rickshaw. The argument that a collision between a two-wheeler, which was a lighter vehicle, with an auto rickshaw carrying 9 people, which was obviously the heavier vehicle, would not result in the overturning of the auto rickshaw cannot really be sustained. The auto rickshaw being a three-wheeler, the probability of it being turtle in the event of a collision at a particular angle is not unfathomable. The claimants have consistently given evidence that the accident occurred as a result of the negligence on the part of the rider of the motorcycle. No evidence is forthcoming from the owner to deny this allegation. And the insurance company has also not produced any evidence to establish that the auto rickshaw driver was also responsible for the accident. If the fact that the charge sheet was laid against the rider of the motorcycle is taken into consideration, it is obvious that in the totality of the circumstances, the finding record with the tribunal that the rider of the motorcycle was alone responsible cannot be found fault with. The Senate Council also put forth an argument that since the auto rickshaw was carrying passengers in excess of its capacity, the liability of the insurance company would not, cannot be, the insurer of the auto rickshaw cannot be made liable. Insurer of the motorcycle cannot be made liable, cannot also be accepted. If the auto rickshaw was carrying passengers in excess of the capacity, that may be an offense under the provisions of the Motor Vehicle Act. But when a motorcycle collides to such an auto rickshaw and causes injuries to the claimants who are third parties, the liability of the offending vehicle and consequently its insurer cannot be wished away. Since admittedly a collision took place and the rider of the two-wheeler was responsible, the insurer of the two-wheeler automatically becomes liable, irrespective of the fact whether the auto rickshaw was carrying passengers within the permissible capacity or contrary to the permissible capacity. The argument of the Not Council is therefore rejected. As far as the appeals filed with the claimant regarding enhancement is concerned, the tribunal, in the case of the death of Arsena, Jayama, has determined the monthly income of Jayama at rupees 5,000. Since there is no documentary evidence to establish the actual income, it would be appropriate to adopt the most income fixed by KSLSA, which for the year 2012 13 would be rupees 8,000. Yeshanade claimants 1/3 of to the said sum. Future prospects of ಎಷ್ಟು 25%. 25% had been added since the deceased was 45 years. This would result in the income to be so on. From the said sum, 1/3 would have deducted, and by applying the multiplier of 14, the claimants would be entitled to some more rupees so on. The claimants being the husband and children, each of them would be entitled to some more rupees 44,000 as loss of consortium, and they would also be entitled to some more rupees 33,000 under the convention acts. Consequently, the appeal filed by the claimants is allowed in part, and they are held to be entitled to the following sums. The said sum shall carry 6%, 8 weeks. MFA 7524 has been filed by the claimant who was injured in the accident. The tribunal has assessed the permanent disability at 10%, though the doctor stated that the claimant had suffered 52% disability. In my view, having regard to the injuries suffered, it would be appropriate to determine the physical disability at 25%, as against the 10% determined by the tribunal. Since there is no evidence to establish the actual income, the notional income of rupees 8,000 fixed by KSLSA is adopted. Consequently, the claimant would be entitled to a sum of rupees 8,000 to 12 into ಎಷ್ಟು multiplier 11 into 25% towards loss of future income. The claimant was admitted as an inpatient for 21 days. That view of the matter, the claimant be entitled to a sum of rupees 30,000 towards food, nourishment, and conveyances, as against 9,300. The tribunal has not awarded any sum towards loss of amenities. Since it is held that the claimant has suffered 25% disability, it would be appropriate to award a sum of rupees 50,000 towards loss of amenities. Consequently, the claimant will be entitled to the following sums: 6% interest, 8 weeks. The appeals of the insurer are dismissed, and the appeal of the claimants are allowed to the extent stated above.
Amount in deposit
ಮಾಡ್ತಿರೋದು ಆಟೋಮೆಟಿಕ್
ಅಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ಗೆ ಹೋಗ್ಬೇಕು ಅದು ಒಂದ್ಸರಿ ಮಾಡಿಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ಗೆ ಹೋಗ್ಬೇಕು
ಅಮೌಂಟ್
ಹ್ಯಾಸ್ ಟು ಗೋ ಟು ದಿ ಟ್ರಿಬ್ಯುನಲ್
ಮಾಡ್ತಿರೋದು ಆಟೋ ಇಟ್ಸ್ ನಾರ್ಮಲ್ ಸ್ಫೂರ್ತಿ ಇದೆ ಸ್ಫೂರ್ತಿ ಅದೇನು ಆಕ್ಟ್ ಓನ್ಲಿ ಪಾಲಿಸಿ ಅಂತಾರೆ ಅದೇನು ಕರೆಕ್ಟ್ ಮಹೇಶ್ವರೇ ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿನ ಅದು
ಹೌದು ನೋಡಿ ಪಾಲಿಸಿ ತಗೊಂಡು ನೋಡಿ
ಕವರ್ ಆಗುತ್ತಲ್ವಾ
ಇಲ್ಲ if your lordship opens the policy, I'll point out B schedule ಅಲ್ಲಿ C.
ಇಲ್ಲ ಬಟ್ ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 2013 ಅಲ್ಲಿ
That you must kindly look into the Malad, the policy. I'll explain to you a lot.
Yes.
Yes. Then Malad, B, liability premium compensation on the right hand side.
Yes.
There you must kindly see, add A, B, C. C, PA cover to pillion rider, no premium is paid. 0.
what is this meaning of PPPD?
Third party property damage.
That all right.
There you must kindly see, except the vehicle Malad, no other Malad PA cover to the Malad owner insured. 50 rupees is paid, all other Malad 000. No premium is collected for passenger or PA cover to the pillion rider, especially C.
No, that is optional PA indicates other than whatever is to be paid.
No, Malad.
Because I want more than the amount that.
Not that Malad. He is a pillion rider. He is not covered and no premium has been paid, extra premium to cover the risk of a pillion rider. There is a provision to pay, but it is not paid under the policy. Especially C, you are not kindly see. Optional PA cover, pillion rider 0.
No, this PA cover, if the premium is paid, that means you will only pay the fixed sum.
Yes, for a fixed sum only, that is also not paid.
No, that is optional.
Otherwise,
That is-
pillion rider is not required to be covered. Only after the Malad, certain premium is collected. According to the premium paid Malad, the slab will be there. Even
No,
PA
according to you, is this a comprehensive policy or not?
it's not a comprehensive policy. You have to kindly look into the Malad, the policy itself.
This policy does not talk about whether it's comprehensive or otherwise. But
Yes.
this policy indicates that you have collected premium for
But
own damage also.
If it is a package policy, Malad, it will be shown as package policy. And Malad, the premium paid will be Malad LC. But here, specifically in B Malad, PA cover to the owner driver Malad is 50 rupees.
Yes.
PA cover to named passenger 0. PA cover to pillion rider 0. So pillion rider is not required to be covered under law, and even under the policy Malad, he is not covered.
Yes. Liability only policy and also package policy. Page number 98. Page number 98, standard policy of liability only policy. There only liability to the third party is covered. That means I was going to go to the 118. Number 118. There, standard forms of two-wheeler package policy. There, section 1, all of the damages to the vehicle is available. The next page, at 121. Next page, 121. Yes. Section 2, liability to the third party. Two columns are there in package policy. If they collect premium under section 1, all under package policy. They collect only to liability to the third party. Will be under section column number 2, that is B column. And the standard policy, liability only policy, page number 98. They are unable, they cannot collect any premium towards the whole damage. They can collect premium to the owner or driver, only owner or driver. And in
package policy they can collect premium towards the own damages, and the next day they can collect premium towards the third one. With this policy, what the insurance company is doing, own damages is collected to the extent of 263 after deduction of the people. And third party premium of 422 and PA coverage is 50 rupees. PA coverage is personal accident coverage. And I also highlighted the page number 118, 121, section 2, subclass 2, 1. Death or body injuries to any person including the occupants carrying it to a medical. So, Honorable Supreme Court holds that if the package policy, the occupants are relying upon this system. And the case, Client Advisory Committee also.
No, but his argument appears to be that this is not a package policy. And he is not stating what is the kind of policy that this is.
This is that they are not any kind of policy as well. Nomenclature of the policy. I policy or a package policy is not there. But under act policy, you collect only premium to.
The insurer, the official of the company was examined.
RW1, madam.
That is not your contention, Mr. Mahesh.
But he had just produced the policy. He doesn't say anything about that.
No. If you are going to say it is not a package policy.
But it's not. But policy itself is produced before the court.
Correct.
Yes.
Now we will assume that it is not a package policy.
Yes.
I'll accept your argument for a minute. Which policy permits you to collect own damage premium?
But even under the Act policy, under the Indian Motor Tariff, my lord, PA cover and third party property own damage is allowed. Therefore, from the policy
Please show me from this tariff advisory committee that even in respect of act only policy.
You have to kindly look into the policy, my lord, where it has been specifically said optional PA cover to pillion rider. No amount is collected.
No, I'm asking you a different question. Is it your case that it is only an act only policy and not a comprehensive policy?
It's not a comprehensive policy.
Then what kind of a policy is this, according to you?
Right, it's an act policy where, my lord, extra premium is paid to collect for own damage and third property and PA.
So that is relatable to this committee report only.
Not that, my lord, if it is so, then, my lord, nomenclature would be, my lord, comprehensive policy.
No, what
not a
nomenclature
package policy.
Now, my doubt is, if you are entitled to issue an act only policy and at the same time collect premium for own damage, that should be permissible under this TAC.
Yes, my lord.
Please show me that particular clause.
It is optional. Therefore, my lord, the word optional is used. Optional. If it doesn't, my lord, opt for it, then there is no cover.
No, I'm not on that. You are saying insurer can issue an act only policy, and in that act only policy, it can also collect own damage premium. Correct?
Yes.
Show me from the TAC that in an act only policy, you can collect own damage.
IMT, my lord, IMT mechanic.
IMT yadu. I have this.
Now, kindly get my lord IMT, my lord. The policy would have to kindly look into limit of liability in the policy.
No, I saw that. And my question to you is, your argument is in an act only policy also, you can collect own damage premium.
Yes,
So
my lord.
from IMT, show me which clause permits you to collect a premium for own damage in respect of act only policy.
But that is according to the tariff, my lord. According
therefore-
to the tariff is collected, but that doesn't make it, my lord, it's a comprehensive or a package policy. Therefore, my lord, that will be, my lord, explicit from B liability premium compensation, section 2. There, my lord, optional PA cover. That shows, my lord, it is not compulsory. If it is a package policy, my lord, that wordings will not be there. It becomes redundant. If it is a package policy, my lord, those wordings will not be there. Two type of risk, my lord, it mentioned, and no premium is collected against that.
Anything else? Anything else?
My submission, my lord, the policy does not cover the, my lord, risk of the, my lord, the pillion rider. Therefore, my lord, the company is not liable.
The argument was
Not a-
also, the argument was also advanced.
That the policy that the certificate of insurance is produced as exhibit R1 as a specific clause pertaining to optional PA cover for the billion rate. And since no premium was collected in this regard, the liability of the insurer to the billion rider will not lie. The Spurti Agri, on the other hand, laid upon the standard form for two-wheeler package policy found in the IMT, India Motor Tariff, to contend that In respect of a package policy, there are two sections. The first section deals with loss of damage to the vehicle insured, and the second section deals with liability to third parties. He stated that according to section 2, related to the liability of third parties, it has been categorically stated that the insurer would become legally liable to pay in respect of death or bodily injury to any person, including occupants carried in the insured vehicle. And therefore, the insurer would be liable for the damages that the pillion rider becomes entitled to as a result of the accident. He also highlighted the fact that the standard form for liability only policy only provided for liability to third parties and collection of personal accident cover for owner and driver, and there was no provision for collecting own damage. And therefore, whenever the premium was collected towards own damage, as per the IMT, it will have to be considered as a package policy. He also placed reliance on the judgment of the apex court, rendered in National Insurance versus Balakrishnan and another 2013 1 SEC 731, wherein it has been held that in case of a comprehensive policy, comprehensive / package policy, the insurer would be liable even for the compensation payable to the pillion rider. The argument of the learned counsel for the insurer that the premium towards optional PA cover for the pillion rider is not collected, and therefore insurer would not be liable, should not be accepted. A personal accident cover is a separate cover which is liable to be paid over and above the entitlement under the Act only policy. For instance, if in an Act only policy, the owner come driver who has opted for a PA cover suffers an injury or a death, the personal accident cover that he had paid for while taking a policy on the vehicle would automatically kick into force, and he would be entitled to the said compensation. The concept of a personal accident cover cannot be correlated to that of a premium collected by the insurer to cover the liability arising out of the use of a motor vehicle. Since it is settled law that if there is a package policy, the liability of the insurer to the occupants of the vehicle, practically in the case of a two-wheeler, including a pillion rider, would be applicable. The argument of the learned counsel to the insurer cannot be accepted, especially when the IMT categorically states that own damage premium could be collected only in case of package policy. And in the incident case, as per the policy produced, own damage premium has also been collected, thereby conclusively indicating that it is a package policy. I therefore find no grounds to accept the arguments of the learned counsel for the insurer. And I did. Don't serious because you wanted it out. ಇವತ್ತಿನ ಡೇಟ್ಗೆ ಆಡಿಟಲ್ ಲಿಸ್ಟ್ more ಅಂತ
Number two. Number one, Ravi Shankar.
I appear for the insurance company, respondent.
ಇಂಜುರಿನ ಡೆತ್
Injury.
ಏನಾಗಿದೆ?
In fact, the doctor who has treated the claimant has not been examined. Though there were two doctors who treated the claimant, but this doctor who had who had not examined the claimant comes before the tribunal and assesses the disability. That is the reason tribunal has not accepted the disability suggested by the said doctor.
What is the injury that he has suffered?
That is para number 12 onwards. Internal page 8. Lacerated wound over the frontal region. Fresh blood oozing from the right ear. Blunt injury to the left side of the chest. In para number 9, the doctor assesses the disability at 20%, the whole body. He was treated as an inpatient for about 13 days. And thereafter, there are no medical records to show that he has continued treatment and which resulted in disability.
Now, please come to page 17.
That is the
Evidence of the neurosurgeon, isn't it?
internal page 9 minute.
Paragraph 14.
14, yes. Evidence of the medical officer, Chandrasekhar, examined in chief. Patient was admitted to the hospital and he has undergone treatment initially at Piriyapatna Government Hospital and later he was shifted here for further treatment. And then, on examination, patient had lacerated wound, so and so. Then the injuries.
No, it is a CT scan of that showed hemorrhagic contusion on the left temporal.
Adella ಇದೆ. 13 days he was treated.
ಆಮೇಲೆ ನೋಡಿ
And thereafter there is no medical records to indicate that he has suffered any severe head injury.
Please read the next portion. Patient treated with antibiotics, anticonvulsions, analysis, and anti-edema medicines. Patient gradually improved and was discharged on 24/9/2007.
Yes.
During follow-up, patient was complaining of giddiness, headache, decreased memory, and deafness of right ear. Patient was treated accordingly with medicines, but the symptoms are persisting. On further evaluation, patient was found to have hearing loss on the right side due to the right ear bleed and decreased memory and speech disturbances. Why should I not accept this?
But
This is a serious injury, isn't it?
it is a
He has decreased
serious
memory.
injury, but
Right ear.
in the next para, there's one para which is not legible. After that, the tribunal assesses the medical evidence and the evidence of the doctor. And why the tribunal has disbelieved its entire para is not.
He has suffered hearing loss and.
The next.
He was 53 years, huh?
60 years ಅಂತ ಇದೆ.
Hospital 53 ಅಂತ ಇದೆ.
60 years ಅಂತ ನಂದು ಸ್ವಲ್ಪ ಪ್ರಿಂಟ್ಔಟ್ ತೆಗೆದಾಗ ಸ್ವಲ್ಪ ಒಂದೆರಡು ಪ್ಯಾರಾ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ tribunal discusses the evidence in its totality, documentary and oral evidence of the doctor. Para number 17 onwards in that.
at GSS Hospital.
Para number 17 onwards. Para 11 and page 11 of internal page 11.
No, the doctor who has given evidence is the doctor who treated him, isn't it?
ಇಲ್ಲ ಅದು ಪ್ಯಾರಾ
No, he
17
should be
ಇಂದ
clear of it.
ಇಲ್ಲ
ಹೌದು. ನಾನು ಚಿಕಿತ್ಸೆ ಕೊಡುವುದಕ್ಕೆ ಮುನ್ನ ಅರ್ಜಿದಾರನ್ನು ಡಾಕ್ಟರ್ ಮೈಥಿಲಿ ನೋಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿ. ಮಿಷನ್ ಆಸ್ಪತ್ರೆಗೆ ಅವರು ತಾರೀಕು 13/9/2007 ಬಂದು ಒಳರೋಗಿಯಾಗಿ ದಾಖಲಾಗಿ ನಾನು ಹಿಂದೆ GSS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೆ, ಈಗ ಮಾಡುತ್ತಿಲ್ಲ.
ಇಲ್ಲ ಈಸ್ ಕಮ್ ಟು ಗಿವ್ ಓನ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಅಸೆಸ್ಮೆಂಟ್ ಅಂತ.
He has produced the case sheet. He has lost the hearing of his right ear and his speech is slurred.
Some that injuries are previously serious in nature, there's no doubt. But the kind of assessment made by the doctor is
Hearing loss of speech and ಎಷ್ಟು percentage of disability?
ಒಂದು 10% ತಗೊಂಡು ಮಾಡಿ ಸರ್.
Speech slur
ಅಲ್ಲ
ಆದ್ರೆ
ಅದರಲ್ಲಿ ಅಲ್ಲ ಅವ್ರದ್ದು ಅಲ್ಲ ಒಂದ್ಸಲ ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ಮೇಲೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ಲಲ್ಲ. ದಿಸ್ ಡಾಕ್ಟರ್ ಹ್ಯಾಸ್ ಕಮ್ ಟು
the CT report clearly indicates he had suffered severe head injury. He had blood oozing from ear.
correct. Of course it requires reassessment, but 20% is on the higher side without the doctor who they were examining the doctor who treated him.
Doctor has examined him and he has said is 20%. And if he has lost the speech capability, it should actually be more for functional disability. If he can't talk, I will hold 20% and increase in the pain and suffering.
It's an accident pertaining to the year 2007.
In respect of an accident which is not in dispute, and the liability of the insurer pay the compensation is also not in dispute. The tribunal has awarded a sum of rupees 70,000. In the following manner. And pain and suffering 10,000. Medical expenses 16,000. Attendant charges conveyance 20,000 loss of conveyance. And 9,000 rupees loss of earnings in later period. The tribunal has
noticed that the CT scan had revealed that the claimant had head injury, and it is also noticed that during follow-up, patient was complaining of giddiness, headache, decreased memory, and deafness of right ear. It is also recorded with the trial court that the doctor who was deposed as PW2 has also stated that on further evaluation, it was found that the claimant had hearing loss on the right side, hearing loss on the right ear, due to the right ear bleed, and he has also had decreased memory and speech disturbances. The doctor ultimately concluded that, deposed that the claimant had suffered whole body disability of 20%. However, the tribunal has refused to accept the said evidence on the ground that the witness who deposed with the tribunal had not treated the patient as an inpatient at CSI Holdsworth Memorial Hospital, Mysore. And he was also not the medical officer who treated the claimant at JSS Hospital. This to be stated here that PW2 was the neurosurgeon working for the past 10 years, prior to his deposition in the KR Hospital, Mysore, which is a government hospital. His evidence also indicates that he had treated the claimant. In the history of the matter, the tribunal was in error in disregarding his evidence and his assessment of whole body disability. I therefore hold that the claimant had proved that he had suffered a disability to the whole body to the extent of 20%. The accident is of the year 2007. There is no credible evidence to ascertain the actual income of the claimant. Therefore, it would be appropriate to adopt the notional income determined by KSLSA for the year 2007, which is rupees 3,500. Consequently, the claimant will be entitled to a sum of rupees 3,500 into 12 into ಎಷ್ಟು multiplier ಅದು 53 ಅಲ್ವಾ? How old is he?
ಅಲ್ಲ ಅದರಲ್ಲಿ in one place it is 60 ಇದೆ cross examine.
Medical report ಏನಂತ 52 ಅಂತ ಹೇಳಿದ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ.
ಕ್ಲೇಮ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ 53 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
52 ಅಂದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
53.
52.
In the claim petition, its age is stated as 53.
53 ಅಂದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? 11. What's loss of
53 is.
That's what the medical record says. It says 52.
ಅದೆಲ್ಲ same 11 ಆಗ್ತದೆ.
The evidence of record indicates that the claimant was an inpatient for how many days?
13 days ಅಂತಿದೆ.
13 days. But 2 hospitals alva.
Inpatient ಅದು 13.
included at the at the government hospital, at their hospital, at CSA, CSA, also at hospital for 11 days. And prior to that, he had undergone treatment at Periyapatna. And he is also taking treatment as an outpatient in JSS Medical College, JSS Hospital. History of the matter, be appropriate to award the sum of rupees 25,000 towards attendant charges, conveyance, food and nourishment. The claimant had produced bills amounting to rupees 29,225. The said claim was disallowed on the ground that
Some part of the bill was disallowed because some bills were not believed by the court because it was prior to the accident. So that's the reason
submitted by the claimant was prior to the accident.
And that's the reason tribunal has assessed 16,000 rupees.
Even if that bill which was produced is excluded, it is to be noticed that the claimant had incurred medical expenditure of 27,225. It is also to be stated here that when the claimant had suffered an head injury and had permanent lasting damage relating to his memory lapse, including memory lapse, the denial of his claim towards medical expenses cannot be sustained. Having regard to the condition of the claimant, it would be appropriate to award a sum of rupees 35,000 towards medical expenses. The tribunal has awarded only a sum of rupees 10,000 towards pain and suffering. Since the surgeon has stated that the claimant has suffered hearing loss, decreased memory and speech disturbances, and has been hospitalized once, twice, and has also been forced to take treatment as an outpatient for several months, it would be appropriate to award a sum of rupees 50,000 towards pain and suffering. The tribunal has awarded a sum of rupees 20,000 towards loss of immunities. In regard to the lasting damage that the claimant has suffered due to the accident, this amount will also have to be enhanced to rupees 50,000. Since the most income is determined as 3,500, it would also be appropriate to award a sum of rupees 6 months towards loss of earnings in the later period. Consequently, the claimant will be entitled to the following sums with 6% interest. Venkatapati.
On this matter, I represent second respondent.
In case of injury or death?
It is a case of death of 72 years, about 72 years old person.
70 years. How much is awarded?
Eitherly, my friend has to first start a canvas argument. Yakandre, Mahesh Shetty probably he will have to start. We have little issues in this. The only person who can be treated as dependent, provided there is any proof. Otherwise, in the class examination, it is clearly admitted that all our graduates are depending on eking out livelihood independently. Ella legal has that has come in the class examination also. And the first appellant in this case, who was the second petitioner in the tribunal, it is stated that she is suffering with depression. But from what date depression started and when it ends, or what is the disability, mental disability or mental ill health she has got,
ಅದಕ್ಕೆಲ್ಲ ದೇರ್ ಇಸ್ ನೋ ಆನ್ಸರ್. ದಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ಲಿ ಆನ್ಸರ್ಡ್ ಬೈ ದ ಟ್ರಿಬ್ಯುನಲ್. ಹಾಗಾಗ್ಬಿಟ್ಟು ಡಿಪೆಂಡೆನ್ಸ್ ನನ್ ಆಫ್ ದ ಕ್ಲೈಮೇಟ್ಸ್ ಆರ್ ಡಿಪೆಂಡೆಂಟ್ ಬಿಕಾಸ್ ಶಿ ವಾಸ್ ವರ್ಕಿಂಗ್ ಆಸ್ ಅ ಟೀಚರ್ ಅಂತಲೂ ಏನೋ ಬಂದಂಗಿದೆ ಅದು.
The second claimant was unmarried, alva?
ಅದು ಹಂಗಾಗ್ಬಿಟ್ಟು ಇವಾಗ ಮಹೇಶ್ ಶೆಟ್ಟಿ he will have to establish his right. Judgment and deposition both are very clear. And notional income 40,000 ತಗೊಳ್ಳಿ because I am coming under section 163 ಅಂತ ಹೇಳಿದ್ದಾರೆ. 163 ಏನಾದ್ರು ಬಂದಿದ್ದಾರೆ ಪೆಟಿಷನ್.
She is 34 years old. She is unmarried. So she was
ಅಂತ ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ. She is already 42 years before this honorable court. And ಇನ್ನೊಂದು ಅಂದ್ರೆ they have not produced any proof, one let alone the age proof.
It does not even
ಡಿಪ್ರೆಷನ್ ಆಗಲಿ ಅಲ್ಲ ಡಿಪ್ರೆಷನ್ ಆಗಲಿ ಏನಾದ್ರು ಆಗಲಿ ಅದಕ್ಕಿಲ್ಲ. ಆಮೇಲೆ ಅವ್ರು ಮೊದಲು ಟೀಚರ್ ಆಗಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಟೀಚರ್ ಸೆಸೆಷನ್ ಆಫ್ ದ ಜಾಬ್ ಅದು ಏನು ಪ್ರೂಫ್ ಕೊಟ್ಟಿಲ್ಲ. ಹೀಗಾಗ್ಬಿಟ್ಟು ಅವ್ರ ಮೆಂಟಲ್ ಇನ್ಕೆಪಾಸಿಟಿ ಅನ್ನೋದಂತೂ ಏನು ಇಲ್ಲ. ಈಗ ಲಾರ್ಡ್ಶಿಪ್ ನ ಕೈಂಡ್ಲಿ ಸಿ.
ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು? ತಂದೆ ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು?
ತಂದೆ ಈ ವಾಸ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಂಡ್ ಆಲ್ಸೋ ಕುಕ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಕ್ಯಾಟರಿಂಗ್ ಸರ್ವಿಸ್ ಮಾಡ್ತಿದ್ರು ಅಂತ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಲ್ಯಾಂಡೇ ಇರ್ಲಿಲ್ಲ ಅಂತ ಒಂದ್ಸಲಿ ಹೇಳ್ತಾರೆ, ಇತ್ತು ಅಂತ ಒಂದ್ಸಲಿ ಹೇಳ್ತಾರೆ. ಒಂದು ಈವನ್ ವಿತೌಟ್ ದೇರ್ ಬೀಯಿಂಗ್ ಎನಿ ಇನ್ಕಮ್, ನೋಷನಲ್ ಇನ್ಕಮ್ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ದೇ ಹ್ಯಾವ್ ಸೀಲ್ಡ್ ದೇರ್ ಇನ್ಕಮ್ ಫಾರ್ 40,000 rupees ಬೈ ಅಡಾಪ್ಟಿಂಗ್ ಟು ಸೆಕ್ಷನ್ 163A. Page number 17 of the judgment and serial number 1780 ಇರ್ತಾರೆ. Judgment page numbers 11 and 12 ಬಹಳ ಕ್ಲಿಯರ್ ಆಗಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಡಿಸ್ಕಸ್ಡ್. ಅಂಡ್ ಪ್ಯಾರಾ 13 ನಲ್ಲಿ ಅವಕಾಶನ್ ಬಗ್ಗೆ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ದಾರೆ.
She has not filed even wakalat or wakalat on her behalf was signed by the brother, and he has said in the evidence that she can't understand anything and therefore he was representing on her behalf. I will take her as a dependent. What is the income as on that date?
ಅಲ್ಲ ಇಲ್ಲಿ ಸೆಕ್ಷನ್ 163A ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
163
A ಸೆಕ್ಷನ್ 163A ಬಂದಾಗ ಇವೆಲ್ಲ ಅಪ್ಲೈ ಆಗಲ್ಲ.
ಅದು ಸುಮ್ಮನೆ ಕೊಡ್ಲೇಬೇಕಲ್ಲ ಹಂಗಾರೆ? ಇದೆಲ್ಲ ಯಾಕೆ ಹೋಗ್ಬೇಕು ಪ್ರಶ್ನೆ ಹಂಗಾರೆ?
ಅಲ್ಲ ಅವರೇ 40,000 ಸೀಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬರಲ್ಲ.
40,000 ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಷ್ಟೇ. I'll go by the second schedule only.
ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಹೋದಾಗ he was 72 years ಆಗುತ್ತೆ. 70 years ತಗೊಂಡ್ರು ಅಲ್ಲಿ ನೋ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇದು ಬರಲ್ಲ, ಅಪ್ಲೈ ಆಗಲ್ಲ. ಅಲ್ಲಿ 70 years ಹೊರಟೋದಲ್ಲೇ ಅವ್ರಿಗೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬರೋದಿಲ್ಲ. ಮಲ್ಟಿಪ್ಲೈಯರ್ ಮೆಥಡ್ ಅಲ್ಲೂ ಸೀಲ್ ಆಗುತ್ತೆ. ಮಿನಿಮಮ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ತಗೋಬೇಕಾಗುತ್ತೆ ಅವರು.
ಎಷ್ಟು ಬರುತ್ತೆ ಹೇಳಿ, ಎಷ್ಟು ಬರುತ್ತೆ ಅಷ್ಟು ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ.
ಅದು
ಕನ್ಸೋರ್ಷಿಯಂ ಅಂತ ಬಂದೇ ಬರುತ್ತಲ್ಲ, ಕನ್ಸೋರ್ಷಿಯಂ ಅಂತ ಬಂದೇ ಬರುತ್ತಲ್ಲ.
ಫಿಲಿಯಲ್ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ವಿ ನೀಡ್ ಟು ಬಿ ಗಿವನ್ ಅದು ಕೊಡ್ಬೇಕಾ ಬರುತ್ತೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಅವರು 163 ನಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟು, ಫ್ಯೂನರಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಮೆಡಿಕಲ್ ಬಿಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಇದಕ್ಕೆ ಕಂಪಲ್ಸರಿ ವಾಟ್ ಇಸ್ ಪ್ರೊವೈಡೆಡ್ ಅಂಡರ್ ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಟು ಬಿ ಗಿವನ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಬೌವ್ 65 years 5 multiplier 2 lakhs.
ಅದೇ
2 lakhs minus 1
ಅಲ್ಲ
2 lakhs minus 1/3 plus loss of consortium ಕೊಡ್ತೀನಿ.
1/3 ಅದಾಗಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ read out the class exams my lord as discussed in page number 11 of judgment.
Correct. This is not perfect. This is defective in the Supreme Court more than one of these ಮಾಡಿದ್ದಾರೆ. So ಯಾವ್ದು ಬೇಕೋ. But I'm not saying you're wrong. I'm saying I'll disagree with that in so far as consortium is concerned. That is all.
Page number 11 judgment ಅಲ್ಲಿ learned judge has discussed it. He stated that except question number 2, all the petitioners are graduates. Second petition is studied up to SLC. That is first appellant before the Honorable Court.
But the tribunal has not considered the evidence given by him in his examination in chief.
At the examination chief there is consistencies on the barth. Proof ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ oral assertions.
So what is there to disbelieve that? Why would he say that his sister is mentally unsound? What will he gain?
They can produce anything. Medical certificate ಆದ್ರೂ produce ಮಾಡಬೇಕು.
All right.
Just oral assertion in respect of depression, that will not be sufficient. If there is depression, continuous treatment will be there. They claim that she was under treatment anta, but no proof is produced. One thing. Second thing is, ಅವರು unmarried ಅನ್ನೋದಕ್ಕೆ at least if they have produced some ration card ಆದ್ರೂ produce ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಬಂದಿದ್ರೆ unmarried dependent ಅಂತ ಆದ್ರೂ ಗೊತ್ತಾಗ್ತಿತ್ತು. ಅದು ಮಾಡಿಲ್ಲ. ಹಾಗಾಗ್ಬಿಟ್ಟು ಅವ್ರು unmarried ಅನ್ನೋದಕ್ಕಾಗ್ಲಿ, she was suffering with depression and dependent ಅನ್ನೋಕ್ಕಾಗ್ಲಿ, there is no proof produced either before the lower court or before the Honorable Court. ಹೀಗಾಗ್ಬಿಟ್ಟು none of them, admittedly all others are graduates and they are living on their own income. ಹಾಗಾಗ್ಬಿಟ್ಟು ಓನ್ಲಿ ಫಸ್ಟ್ ಅಪೆಲೆಂಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿಸ್ ಕ್ಲೈಮ್ ಅವರು ಪ್ರೂವ್ ಮಾಡ್ಕೋಬೇಕಾಗಿದ್ದು she is a dependent, she is depressed, so she is not able to earn out her livelihood and she is unmarried. ಈ 3 ಪಾಯಿಂಟ್ಸ್ ಅವರು ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು. ಅದಕ್ಕೆ there is no supporting any evidence before the Honorable Court also. ಹಾಗಾಗ್ಬಿಟ್ಟು we cannot treat her as dependent. If to be treated ಅಂದ್ರೆ matter has to be again remanded and she will have to establish all the things and then she will have to come back.
Please read 163A.
Oh, 163A petition.
Now please read 163A. They don't have to prove their dependency at all. If the claim is under 163A, if the accident is established, you'll have to pay the compensation to the legal heirs of the victim. They don't have to prove anything. You are importing a concept of dependency now in a 163A proceeding. This is given to one set of people whose income is less than 40,000. With respect to 166, yes, they have to prove dependency. 163 ಅಲ್ಲಿ ಬಂದು dependency prove ಮಾಡೋದು? You're converting it
ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
No, what is the relevance of dependency in 163A?
ಅಲ್ಲ, ಇನ್ಕಮ್ ಪ್ರೂಫ್ ಗೆ where there is no income proof ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಹೋಗಬೇಕಾಗುತ್ತೆ ಅಂತ ಅದನ್ನ ಅಪ್ಲೈ ಮಾಡ್ಕೊಳಕ್ ಆಗುತ್ತೆ.
This is a claim on 163A.
ಹೌದು ಸರ್, 163 ನಲ್ಲಿ.
If 163A claim, if it is 163A claim, this is under 163A only. All they have to prove is the death occurring out of the use of a motor vehicle.
Usage of the motor vehicle. That is accident is not at all in dispute.
That is established. Your liability to pay compensation cannot be escaped. Whether they are dependent, not dependent, it's of no consequence.
I am not escaping from liability. I am not disputing accident. But only thing is, they have not proved their right for the extent they claimed. That is my issue.
That's why I said read 163A. It says you shall pay compensation to the legal heirs of the victim. It does not say you will pay compensation only if the legal heirs of the victim are dependent on the deceased.
Yes, madam.
Then,
ಹೌದು.
then where is the question of dependency? All that. Even if they're not dependent, you will have to pay.
ಆ ರೀತಿ ಹೋದಾಗಲೂ ಏಜ್ ಫ್ಯಾಕ್ಟರ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ.
72, I'll go above 65 years. 5
Above
multiplied
65 years,
40,000,
5
2 lakhs.
multiplier ಬರುತ್ತೆ.
2 lakhs minus
I
1.
admit 5 multipliers ಅವ್ರು ಕೊಡ್ಬೇಕಾ ಬರುತ್ತೆ. ಆದರೆ ಕೊಡ್ಬೇಕು ಅಂತಂದ್ರು ಅವ್ರಿಗೆ ಇದು ಏನೋ ಇನ್ಕಮ್ ಈ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನ್ ಬಂದಿದೆ ಅಷ್ಟು ಮಾತ್ರ ಎಲಿಜಿಬಿಲಿಟಿ ಇದೆ.
40,000 ರೂಪಾಯಿ ಮ್ಯಾಕ್ಸಿಮಮ್ ಅವ್ರು ಕೇಳಿರೋದು ಎಷ್ಟು?
ಮ್ಯಾಕ್ಸಿಮಮ್ ಆಫ್ ದಟ್ ಅದಲ್ಲಿದೆ. ಆಮೇಲೆ ಇದು ಲಾಸ್ಟ್ ಎಸ್ಟೇಟು ಎಕ್ಸ್ಪೆನ್ಸ್, ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಇದೆಲ್ಲ ಏನ್ ಸೀಲಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆ ಲಿಮಿಟ್ ಅಲ್ಲೇ ಇರಬೇಕಾ?
That I'm differing. Loss of consortium, conventional rates, I'll go by Pranay Seethi's case, not go by this.
ನಾ ಏನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ. ಬಿಕಾಸ್ ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಫಾಲೋ ಮಾಡಿ ಸೆಕೆಂಡ್ ಶೆಡ್ಯೂಲ್ ಫುಲ್ಲಿ ಫಾಲೋಡ್ ಅಂತಂದ್ರೆ ದೆನ್ ಜಸ್ಟಿಸ್ ವಿಲ್ ಪ್ರಿವೈಲ್. ಅದರ್ವೈಸ್ ಏನಾಗುತ್ತೆ, ಡಿಸ್ಕ್ರಿಮಿನೇಟರಿ ಆಗುತ್ತೆ.
I consider the appeal is by the claimants. Claimants made an application under section 163 capital A of the Motor Vehicles Act, seeking for compensation for the death of their father, who was admittedly killed in an accident arising out of use of a motor vehicle. The tribunal has proceeded to record a finding that the dependency of the claimants on the deceased had not been proved, and it has proceeded to award only a sum of rupees 75,000 towards loss of estate, 10,000 towards loss of love and affection, and a sum of rupees 2,000 towards funeral expenses, apart from the sum of rupees 5,200 for medical expenses. In a proceeding under section 163 capital A of the Motor Vehicle Act, all that has to be established is that an accident occurred out of the use of a motor vehicle, which resulted in the death or disablement of any person. If this factum is established, the victim of the accident or the legal heirs of the victim are entitled as a matter of right to the compensation as determined in the second schedule. The question as to whether the claimants are dependent or not on the deceased is an irrelevant factor in these proceedings. The tribunal has therefore held in examining the question as to whether the claimants were dependent on the deceased. The claimants contended that their father was earning 40,000 rupees out of the catering business that he was running. In my view, there's absolutely no reason to disregard this assertion when the evidence on record indicates that 3 of his children are graduates, which by itself indicates the financial earning capacity of the deceased. No doubt, probably because he was aged about 68 years.
70 ಫೈಂಡಿಂಗ್ ಇದೆ.
Now
Finding. ಹೌದು
probably because he was aged about 70 years. His income would have fallen in the region of rupees 40,000. Therefore, of the view that the claimants would be entitled to the compensation prescribed under Schedule 2 of the Motor Vehicle Act. According to the second schedule, since the claimant was aged about 65 years and was earning a sum of rupees 40,000, he would be entitled to sum of rupees 2 lakhs as compensation. Out of this sum, 1/3 would have deducted towards his personal expenses, which would result in the compensation of rupees 7. The second schedule prescribes the amounts to be paid towards funeral expenses, loss of consortium, and loss of estate. The second schedule was incorporated in the year 1988, and the apex court in more cases than one has opined that the second schedule was defective, and the amounts mentioned therein, including the notional income, should not be followed blindly. In this year, the matter, in my view, it would be appropriate to adopt the sums determined by the constitutional bench in this case for awarding sums towards loss of consortium and under the convention rates. As a consequence, the claimants being the children would each be entitled to some rupees 44, and they would also be entitled to some rupees 33,000 under the convention rates. The appeal, the claimants are thus entitled, for instance, appeal is allowed in part 6%.
ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಸರ್ 5,330
Appeal for the appellant, Lord. Like two appeals, 721, 723 of 12, Lord. The appellant has not served a copy of the appeal memo.
In matter Indian appeal,
My matter is, my lord, that a false claim has been made against the insured vehicle. For
implication. Vehicle has been implicated, and no accident.
Yes, implicated.
Why do you say that?
Yes. The date of accident, my lord,
Yes.
is on 29/9/2008.
Yes.
On Biddi Kengeri railway station.
Yes.
Yes. But one Santosh Kumar was, my lord, riding motorcycle K04EW 8004.
Yes.
And pillion rider is, my lord, one Muttanna.
Yes.
According to them, my lord, when they were riding, my lord, the motorcycle, the insured motorcycle, my lord, came from the opposite direction and dashed against them and ran away. The complaint, my lord, is after 18 days. The wound certificate and discharge summary says, my lord, injury due to fall. In both the cases, my lord, discharge summary, they have also produced, my lord. I have also produced, my lord, MLC to show that it was due to fall. On a road hump, my lord, they ran the vehicle and fell down and sustained injury, and they were taken to the hospital, my lord. They don't give the, my lord, the vehicle number implicated. After 15 days, my lord, a complaint is lodged. There, my lord, for the first time, my lord, they implicate.
Where is the complaint?
Yes. Exhibit P1 may kindly be looked into.
Who gave the complaint?
Well, complaint is by, my lord, one Muttanna pillion rider.
Yes.
P1. ಸ್ವಾಮಿ ತಾರೀಕು 29/9/2008 ಸೋಮವಾರ ದಿನ ನನ್ನ ಕಂಪನಿ ಕೆಲಸ ಮುಗಿಸಿಕೊಂಡು ಸಂತೋಷ್ ಕುಮಾರ್ ಎಂಬುವರ ಬೈಕಿನಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಸುಮಾರು ರಾತ್ರಿ 9:30 ಗಂಟೆಗೆ ಕೆಂಗೇರಿ ಉಪನಗರದ ಕಡೆಯಿಂದ ಮಾಗಡಿ ರೋಡಿನ ಕಡೆಗೆ ಬರುತ್ತಿದ್ದಾಗ ರೈಲ್ವೆ ಸ್ಟಾಪ್ ಕೆಂಗೇರಿ ಹತ್ತಿರ ಎದುರುಗಡೆಯಿಂದ ಬೈಕ್ ಸವಾರ ಆದ ವ್ಯಕ್ತಿ ಬೈಕ್ ಅನ್ನು ಅಜಾಗರೂಕತೆಯಿಂದ, ನಿರ್ಲಕ್ಷ್ಯತೆಯಿಂದ ಮತ್ತು ಅತಿ ವೇಗವಾಗಿ ಮಾಗಡಿ ರಸ್ತೆಯಿಂದ ಕೆಂಗೇರಿ ಕಡೆಗೆ ಬಂದು ರೈಲ್ವೆ ಸ್ಟಾಪಿನ ಹತ್ತಿರ ನಮ್ಮ ವಾಹನವನ್ನು ಚಲಾಯಿಸುತ್ತಿದ್ದ ಸಂತೋಷ್ ಕುಮಾರ್ ಬೈಕಿನ ನಂಬರ್ KA04EW 8004 ಈ ಬೈಕಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ಪರಾರಿಯಾಗಿರುತ್ತಾನೆ. ಅವನು ನಮ್ಮ ವಾಹನದ ಬಲಗಡೆ ಬದಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ಹೋಗಿರುತ್ತಾನೆ. ನಾವು ವಾಹನವನ್ನು ಎಡಬದಿಯಲ್ಲಿ ಚಲಾಯಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೆವು. ಡಿಕ್ಕಿ ಹೊಡೆದು ಅಪಘಾತ ಉಂಟಾದ ಕಾರಣ ನಾವು ಕೆಳಗೆ ಬಿದ್ದೆವು. ಗಾಡಿಯನ್ನು ಬಿಡುತ್ತಿದ್ದ ನನ್ನ ಸ್ನೇಹಿತನಾದ ಸಂತೋಷ್ ಕುಮಾರ್ ನಿಮಗೆ ತಲೆ, ಕೈಕಾಲು, ಮೈಗೆ ಗಾಯವಾಗಿ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಆತನು ಬಿದ್ದನು ಮತ್ತು ಇದರಿಂದ ಹಿಂಬದಿಯ ಸವರ್ನಾಗಿದ್ದ ನಾನು ಕೆಳಗೆ ಬಿದ್ದು ನನ್ನ ಮೂಗು, ನೆತ್ತಿ ಮತ್ತು ತಲೆ, ಕೈಕಾಲುಗಳಿಗೆ ಗಾಯವಾದವು. ನಂತರ ನಮ್ಮನ್ನು ಸಾರ್ವಜನಿಕರು ಕೆಂಗೇರಿ ಉಪನಗರದಲ್ಲಿರುವ ಸಹನಾ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲೆ ಮಾಡಿರುತ್ತಾರೆ. ನಾವು ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದೇವೆ. ನಮ್ಮಿಬ್ಬರಿಗೂ ತುಂಬಾ ಗಾಯ ಉಂಟಾಗಿದ್ದರಿಂದ ಮತ್ತು ಗಾಬರಿಯಿಂದ ದೂರನ್ನು ತಡವಾಗಿ ನೀಡುತ್ತಿದ್ದೇವೆ. ಈ ಎದುರುಗಡೆಯಿಂದ ಚಲಾಯಿಸಿಕೊಂಡ ಬಂದ ಬೈಕ್ನ ನಂಬರ್ KA04 3275 ಆಗಿರುತ್ತದೆ. This is on 17/10/2008, whereas the date of accident alleged is 29/9/2008.
Yes.
This is to the Batranpura police station. Then, my lord, the Panchanama, my lord, is exhibit P4 on 17/10/2008. Between 9:30 PM to 6:30 PM. Here, my lord, you have to kindly see how this Malad Panchanama has been created. ಬೆಂಗಳೂರು ನಗರದ ಬ್ಯಾಟರಾಯನಪುರ ಸಂಚಾರ ಪೊಲೀಸರು ಠಾಣೆಯ ಮೊಕದ್ದಮೆ ನಂಬರ್ 304/08 ಕಲಂ 279 337 ಭಾರತೀಯ ದಂಡಮಾನಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳವನ್ನು ಪಂಚನಾಮ ಬ್ಯಾಟರಾಯನಪುರ ಸಂಚಾರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಉಂಟು ಮಾಡಿದ್ದು ರಾಜು ಅವರು ಮತ್ತು ತಮ್ಮ ಸಿಬ್ಬಂದಿಯವರು ಅಪಘಾತ ಸ್ಥಳಕ್ಕೆ ಬಂದಿರುತ್ತಾರೆ. ಸ್ಥಳದಲ್ಲಿದ್ದ ಈ ಕೇಸಿನ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರರು ನೇಮ್ ಮಲಾಡ್ is not forthcoming. Who are the ಮಲಾಡ್ ಅಪಘಾತ ಸ್ಥಳವನ್ನು ಗುರುತಿಸಿ ತೋರಿಸಿರುತ್ತಾರೆ. ಸ್ಥಳದಿದ್ದಿಲ್ಲ ನಮ್ಮ ಅನ್ನೋ ಈ ಕೇಸಿಗೆ ಪಂಚಾಯತ್. This is how ಮಲಾಡ್ the spot master has been created, ಮಲಾಡ್. Implicating for the first time.
Suppose we accept the fact that no other vehicle was involved. They did not have any insurance on their motorcycle.
No, that is not the case at all.
No, I'm asking you whether they had insurance on their motorcycle.
But
Did
they have to say.
Have they arrayed them as parties?
Well, yes, but it is for them to say whether their vehicle is insured or not.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, ಅವ್ರ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಮಾಡಿಲ್ಲ ಪಾರ್ಟಿ.
ಅಲ್ಲ, ಅದನ್ನೇ ನಾವು ಹೇಳೋದು. They don't make the insurance company as a party. Drivers are not a party. Then the motorcycle inspector report is on 18/10/2008. It is only in respect of Malad insured vehicle, not the other vehicle which they were riding. Both vehicles were not subjected to Malad IMA. Then exhibit P7, Malad, wound certificate issued by Sahana Hospital.
Dismissing the appeal. I'm dismissing their appeal. ನಿಮ್ದು ಅಪೀಲ್ ಅಲೋ ಮಾಡ್ತೀನಿ, ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
Please.
MFA 760/2012, MFA 761/2012. It's prepared by the insurer, challenging the finding of the tribunal
that an accident occurred in which the rider of the motorcycle and the pillion rider suffered injuries for which they were held to be entitled for compensation. MFA 721 by 2012 and MFA 723 by 2012 has been preferred by the claimants seeking for compensation. It is not in dispute that even according to the claimants, the accident occurred on 29/9/2008 at about 9:50 p.m. and they were initially admitted to the Sahana hospital. As per exhibit P8.
P7, P8.
The wound certificate issued by the said Sahana hospital indicates that we suffered the injuries as a result of a self fall from a two-wheeler. The wound certificate and the discharge summary which are produced as P7 and P8 indicate the insurer has also produced the medico-legal case report of the claimants as per exhibit R5. In this medico-legal report of Sahana hospital, it is stated as follows. As could be seen from the said report, the claimant suffered only lacerated wounds and both of them were conscious and oriented. The fact that the claimants themselves reported to the hospital authorities that they had a fall while avoiding a rodum when they were conscious is itself proof of the fact that no accident had actually occurred as contained in the claim petition. In the claim petition, it is contended that they were hit by another motorcycle. It is also to be noticed here that though the claimants suffered only simple injuries as per exhibit R5 and R as per exhibit R5, they have lodged a complaint alleging that an accident occurred between their motorcycle and another motorcycle. After how many days? Justina? Hmm. 1710, that is after 19 days. If the claimants had really suffered an accident by result of a collision with another motorcycle as contended in the claim petition, they would have, in the normal circumstance, the normal course of human conduct, stated so when they were being treated at Sahana hospital. The fact that they categorically state while being conscious that they suffered the injuries as a result of self-fall while avoiding a rodum by itself is conclusive proof that that their motorcycle was not hit by another motorcycle.
and therefore of the view that the finding of the tribunal that an accident occurred between their motorcycle and another motorcycle cannot be accepted. And since they have chosen not to array their insurer as respondents, their entitlement to compensation cannot be considered. The claim petitions are accordingly dismissed. As a result, the appeals filed by the insurer is allowed. And since I have held that no accident occurred as contained in the claim petition, the appeals filed by the claimants for enhancement would not survive for consideration. The impugned award, the tribunal awarding compensation is accordingly set aside.
Pay for the appellant.
In dispute ಇದರಲ್ಲಿ ಲಿಂಗರಾಜ್
ಇಲ್ಲ ಕ್ವಾಂಟಮ್ ಅಷ್ಟೇ ಇದರಲ್ಲಿ ಇಂಜುರಿ ಟು ಮೈನರ್ ಬಾಯ್ ಇದರಲ್ಲಿ ದಿ ಆಕ್ಸಿಡೆಂಟ್ ಹ್ಯಾಸ್ ಅಕರ್ಡ್ ಆನ್ 1/10/2007 near Lakshmi Bakery, Baireshwar, Mysore, involving one motorcycle. I contested the charge sheet is against a motorcycle because the cyclist dashed against the boy. I contested the proceedings saying that there is no DL to the rider of the motorcycle. I called upon the owner to produce the DL. There is no response. I have also taken out summons to him. There is no response. However, other than that, no evidence was let in. The MACT after trial grants 1,70,000 at the different heads. Doctor is examined and doctor says that fractures have united with thickening, and doctor has assessed the disability to the limb at 20%. The MACT grants 1,25,000 towards pain and suffering and 10,000 towards medical expenses and loss of income towards parents at 20,000. Diet and attendance charges 15,000.
What was the injury suffered by him, by the boy?
Fracture of femur. Left femur.
Who was the doctor who was examined?
Doctor examined as just Kaladegi PSM, PW2. May I read his
Yes.
cross-examination oath? But I have treated the claimant conservatively on 6/10. I have examined him only on. I have no records to show that after discharge he had taken a follow-up treatment. In the KR hospital OP records maintained, I have no information regarding treatment of the claimant, and he told me that he had taken Vinayak hospital. Fracture is
Where does he
united with
work?
thickening is
Where does she work? This Kaladevi?
our hospital.
Kaladegi.
Kaladegi works as in government hospital Mysore. ಪ್ರಾಧ್ಯಾಪಕರು ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರು ಮೂಳೆ ಹಾಗೂ ಕೀಲು ವಿಭಾಗ ಮೈಸೂರು ಅಂತ ಹಾಕ್ಯಾರ. ಯಾರ್ ಹಾಸ್ಪಿಟಲ್ ಇದು?
She's a doctor who treated him.
That's what he said. Yes. ಅವ್ರು 20% to the limb ಹೇಳ್ತಾರೆ.
See the second portion, second page of her evidence. ಎಡಗಾಲಿನ ತೊಡೆಯ ಮಾಂಸದ ಮತ್ತು
ಎಡಗಾಲಿನ ಮಾಂಸಖಂಡ ಗಾತ್ರ ಬಲಗಾಲಿಗೆ ಹೋಲಿಸಿದಾಗ ಕಡಿಮೆ ಆಗಿರುತ್ತದೆ. ಬಲಗಾಲಿಗೆ ಹೋಲಿಸಿದಾಗ
ಎಡಗಾಲು 1 ಸೆಂಟಿಮೀಟರ್ ಚಿಕ್ಕದಾಗಿರುತ್ತದೆ.
ಅದೇ
ಮೂಳೆಯ ಮುರಿತಕ್ಕೆ 10% ಶಾಶ್ವತ ಅಂಗಹೀನತೆ ಇರುತ್ತದೆ ಮತ್ತು ಹಾಗೂ ಮಾಂಸಖಂಡ ಗಾತ್ರ ಕಡಿಮೆ
ಆಗಿರುತ್ತೆ. 5% ಮತ್ತು 1 ಸೆಂಟಿಮೀಟರ್ ಕಿರಿದು ನೋವು ಬಾಧ್ಯತೆಗೆ 5%, ಸುಮಾರು 20% ಶಾಶ್ವತ ಅಂಗನ್ಯೂನ್ಯತೆ ಎಡಗಾಲಿಗೆ ಆಗಿರುತ್ತದೆ. ಅಂಗನ್ಯೂನ್ಯತೆ ಮೀನ್ಸ್ ಇಟ್ ಹೋಲ್ ಬಾಡಿ ಇಟ್ ಕಮ್ಸ್ ಟು ರಫ್ಲಿ ಅರೌಂಡ್ 7%.
1 centimeter shortage ಇದೆಯಲ್ಲ.
ಅದೇ 1,25,000 ಅಮ್ಯುನಿಟೀಸ್ ಒಂದಿಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಇದು ಮಾಡ್ಬೋದು.
Loss of marriage prospects.
1 ಸೆಂಟಿಮೀಟರ್ಗೆ ಏನ್ ಆಗಲ್ಲ, ಅವ್ನು 6 ವರ್ಷದ ಹುಡುಗ ಇಷ್ಟೊತ್ತಿಗೆ
ನಮ್ಮನೆ ಹೆಣ್ಮಕ್ಳು ಕೊಟ್ಬಿಡ್ತೀವಿ ಯಾರು ಕುಂಟನ್ಗೆ.
ಕುಂಟ ಅಂತ ಹೇಳ್ಬಿಡಿ ಪಾಪ.
1 centimeter ಇನ್ನೇನು
1 centimeter ಕುಂಟ ಏನು ಆಗಿರಲಿಲ್ಲ ಪಾಪ. ಹೋಪ್ಫುಲಿ ವುಡ್ ಹ್ಯಾವ್ ರಿಕವರ್ಡ್ ಬೈ ದಿಸ್ ಟೈಮ್ ಬಿಕಾಸ್ ಫ್ರಾಕ್ಚರ್
ನಡಿಬೇಕಾದ್ರೆ ಕುಂಟೆ ಕುಂಟ್ತಾರಲ್ವಾ 1 centimeter
ಎಲ್ಲರಿಗೂ.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು
ಟೋಟಲಿ ಕಾಂಪನ್ಸೇಷನ್ 1,70,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಮಾಸ್ಟರ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸ್ ಪ್ರಕಾರ ಅದು ಆಕ್ಚುಲಿ ಓನ್ಲಿ 1,10% ಒಳಗಡೆ ಇದ್ರೆ
20% ಇದ್ರೆ
ಪೇರೆಂಟ್ಸ್ ಇದು 20% ಲಿಂಬ್ ಇದೆ, ಅದು ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ, ಹೋಲ್ ಬಾಡಿ ಹೇಳಿಲ್ಲ ಅವರು. $170,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳ್ತಾರೆ.
ಮೆಡಿಕಲ್ ಬಿಲ್ 1,10,000 ಆಗಿದೆ ಅಂತಂದ್ರೆ
ಇಲ್ಲ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. MSCTನವ್ರು ಅದು ನೋಡಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸಿಬಿಟ್ಸ್ 6,500,000 ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. MSCTನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಆಸ್ ಪರ್ ಎಕ್ಸಿಬಿಟ್ P8 to P24 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 6,500,000 ಕೊಡ್ತಾರೆ ಬಿಲ್, ಅದಕ್ಕೆ 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ದಿನ ಇದೆ ಹಾಸ್ಪಿಟಲ್ ಅವನು?
5 ದಿವಸ ಇದ್ರು.
2-3 ಹಾಸ್ಪಿಟಲ್ ಹೋಗಿದಾನಲ್ವಾ?
ಇಲ್ಲ, ಅವನು ಅಗೇನ್ಸ್ಟ್ ಮೆಡಿಕಲ್ ಅಡ್ವೈಸ್ ಇದಾಗಿ ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ದ ಸೇಮ್ ಡಾಕ್ಟರ್ ಅವ್ರು ಬೇರೆ ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗ್ಯಾರ ಅಷ್ಟೇ. ಅವರು
ಆಯ್ತು. ಲಾಸ್ ಆಫ್ ಕಮ್ಯುನಿಟೀಸ್ ಎಷ್ಟು ಕೊಡ್ಲಿ?
50,000 ಕೊಡು.
ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್
ಅಲ್ಲ ಎಲ್ಲ ಸೇರ್ಸೇ ನಾನು ಹೇಳ್ತಿದ್ದೆ. ಆಕ್ಚುಲಿ ಮಾಸ್ಟರ್ ಇಲ್ಲ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಹುಡುಗ ವುಡ್ ಹ್ಯಾವ್ ರಿಕವರ್ಡ್ ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. 2007 ಆಕ್ಸಿಡೆಂಟ್, ಹೋಪ್ಫುಲಿ ವುಡ್ ಹ್ಯಾವ್ ರಿಕವರ್ಡ್ ಬಿಕಾಸ್ ಪೇರೆಂಟ್ಸ್ ಸಫರಿಂಗ್ ಆಗಿದೆ. 2007 ಆಕ್ಸಿಡೆಂಟ್ ನೋಡ್ರೆ 1,25,000.
ನೀವು ಅಪೀಲ್ ಹಾಕಿದ ಏನಕ್ಕೆ ಮತ್ತೆ?
ನಾನು ಅದೇ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ, ನಾನು ಐ ಕಾಲ್ಡ್ ಅಪಾನ್ ದಿ ಓನರ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್, ಇರ್ಲಿಲ್ಲ ಅಂತ.
In respect of an accident which is not in dispute and the liability to pay the compensation to the insurer is also not in dispute, the tribunal has awarded a sum of rupees 1,70,000 compensation for the injuries suffered by the claimant who was aged about 6 years as on the date of the accident. The insurer is an appeal contending that the rider of the motorcycle did not possess a driving license, and the claimant is also an appeal seeking for enhancement of compensation. As regards the appeal of the insurer is concerned, apart from contending that the driver of the motorcycle did not possess a driving license, no evidence is adduced to establish this fact. In my view, since even if it is assumed that the rider of the motorcycle did not possess a driving license for the sake of argument, nevertheless, insofar as a third party like the claimant is concerned, the insurer would be liable to pay compensation. Therefore, I find no merit in the appeal of the insurer and the same is dismissed. As regards enhancement, the tribunal has awarded a sum of 1,25,000 as compensation to the claimant suffering, taking note of the fact that the claimant suffered 20% disability according to the doctor who treated it, and he also suffered a shortening of 1 centimeter in one of his legs. The said sum awarded is just and proper and does not call for any enhancement. The tribunal has also awarded some rupees 10,000 to expenses and rupees 20,000 towards loss of earning to the parents. And this amount being reasonable is affirmed. The tribunal has awarded some rupees 15,000 towards right and attendant charges. I find no reason to enhance the said sum. However, the tribunal has not assessed any compensation towards Basa communities. Since the claimant's leg is shortened by 1 centimeter, it would be appropriate to award some rupees 50,000 towards loss of communities. Consequently, the claimant will be entitled to some rupees 2,20,000 as compensation instead of 1,70,000. 6%, 8 weeks. Bill of the injury is dismissed. Bill is awarded in part.
Much obliged. Amount has to be transferred.
With your lordship, serial number 3, my lord.
Yes.
Amount in deposit to be transferred to MSCT for refund ಅಂತ ಮಾಡಬೇಕು. Refund to the appellant. ಅದು ಬರಿದೆಲೆ ಇದ್ರೆ ಕಳಿಸೋದಿಲ್ಲ ಅವರು.
ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರ ಅಲ್ಲಿ ಮಾಡಿದಿರ.
ಅಲ್ಲ ಇಲ್ಲಿ ಮಾಡಿರೋದು ಇಲ್ಲಿ ಅಕೌಂಟ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಸರಿಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ ಮೇ ಬಿ ಟ್ರಾನ್ಸ್ಫರ್ ಟು MSCT ಟು ಬಿ ರೀಫಂಡೆಡ್ ಟು ದಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. Unless a specific order is passed, they don't need it.
The registry is likely to refund the money to the insurer.
ಅಲ್ಲ ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಬೇಕು.
ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ.
ಪ್ಲೀಸ್.
Appeal is by the claimants, my lord, seeking enhancement. The other appeal is by the my lord insured, my lord, disputing the liability.
On what ground are they challenging the liability?
My lord, they first time in the appeal they contend that my lord the claimant was a cleaner in a passenger bus, my lord, and therefore it is not covered.
Cleaner in a passenger bus.
My lord, cleaner in a passenger bus, my lord.
What did you say that you were?
My lord, so far as that aspect is concerned, my lord, there was no defense, my lord, nor there was any evidence on that aspect by the company, my lord, before the MACT. Even in the written statement, they does not take any such defense, my lord. And my lord,
Who's the third respondent?
my lord, the policy holder, my lord.
And first respondent?
He is the owner of the bus, my lord, and the third respondent is the policy holder.
Why are they two different people?
My lord, it seems that, my lord, the policy was in the name of third respondent, and later, my lord, it was transferred to the first respondent, my lord. During the pendency of that validity of the
Then bus ಅದು.
ಹೌದು, ಪ್ಲೀಸ್ ಮೇಡಮ್.
The ground in the appeal is that since it is a bus,
Passenger
their
bus,
liability is not to cover the cleaner. Package policy ಎಲ್ಲ ಕವರ್ ಆಗುತ್ತಲ್ವಾ?
Lord, I am not having the copy of the policy.
Package policy bus
Exhibit R1 is the policy.
All occupants cover ಆಗಲ್ಲ. ಆಕ್ಯುಪೆಂಟ್ ಅರ್ಥ ಬಸ್ ಒಳಗಡೆ ಆಕ್ಯುಪೈ ಮಾಡ್ಕೊಳ್ಳೋರು. They are employees. They are also occupants. The word used in your thing is occupants. Everybody who occupies a place inside the bus is an occupant. Yeah. ಇದ್ರ ಹೆಸರು ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಕೇಸ್ ಹೆಸರು ಗೊತ್ತಾ? ಸೈಟೇಷನ್ ಹೆಸರು, ಪಾರ್ಟಿ ಹೆಸರು ಏನಾರು?
I'm not sorry for the interruption.
Yes.
ತಾವು ಏನು ಕ್ಲೀನರ್ ರಿಸ್ಕ್ ಇಸ್ ನಾಟ್ ಕವರ್ಡ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
ಇದ್ರೆ ಅದರಲ್ಲಿ
ಇದೆ ಅಲ್ಲ, ನಾನು ಇಲ್ಲ. ಜಸ್ಟ್ ಥಾಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೇ ಬಿ ಲುಕಿಂಗ್ ಟು ದ ಜಡ್ಜ್ಮೆಂಟ್. ಕೇಳ್ದಂಗ ಆಯ್ತು, ನನ್ನ ಕೊಲ್ಲಿಗೆ ಹೇಳಿದ್ರು, ಕೇಳ್ತಾ ಇದ್ರು ಸಾಹೇಬ್ರು.
ಯಾವುದು?
ಅಲ್ಲ, ತಾವೀಗ ನೋಡ್ತಾ ಇರೋದು ಕ್ಲೀನರ್ ಇನ್ ಎ ಪ್ರೈವೇಟ್ ಬಸ್ ಕವರ್ ಇದೆ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೇಳಿದ್ರಿ ಅಂತ ನನ್ನ ಕೊಲ್ಲಿಗೆ ಹೇಳಿದ್ರು.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದೆ ಇದೆ.
ಯಾವುದು?
ಅದು ACJ 2003 I mean 1550 Ramashraya Singh. My lord gives me time. Supreme Court. ACJ 2003 page 1550.
Give me the name once again.
Ramashraya Singh versus New India Assurance Company. Am I audible?
Yes, yes.
Ramashraya Singh, RAMASHRAY. Ramashraya Singh versus New India Assurance Company. ACJ 2003 1550. That says cleaner's risk is not covered in private bus center. I may be wrong.
By referring to that judgment, my lord, may I submit, my lord?
Yes.
By referring to the judgment reported in 2003 ACJ 1550, my lord, the learned single judge of this honorable court in MFA 2566 of 2009, my lord, disposed of on 4th September 2005 has held that, my lord, if the policy is a package policy and extra premium is collected towards an employee and claim was made by only the cleaner, and therefore even cleaner comes under the term employee, and thus, my lord, has said that insurance company is liable to satisfy the award.
But the word here we use is paid driver, not cleaner.
Paid driver ಅಂದ್ರೆ ಕೊಡಬೇಕಾ?
ಅಲ್ಲ,
For the cleaner.
ಅದು ಆಕ್ಟ್ ಪಾಲಿಸಿ ಆದ್ರೆ ಬರಲ್ಲ ಅಂತ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. 2014 ಅಲ್ಲ, ಇನ್ನೊಂದು ತಾವು ಮೈ ಲಾರ್ಡ್ಸ್ ವಾಟ್ ಡಿಸ್ಟಿಂಗ್ 2014 14 ಪಾರ್ಟ್ SCC 243 14 part SCC 243 Sanjeev Kumar versus National Insurance. Of course, this is with respect to Act policy.
So if it's a package policy, then they have to pay.
Idರಲ್ಲಿ the Ramashraya Singh ಅಲ್ಲಿ may read the head note. Yes, lots may. 140 is a motor insurance claim for death of Kalasi. ಅಂದ್ರೆ ಅವನು ಇದು ಕಂಡಕ್ಟರ್. Liability of insurance company. Policy covers the risk of 13 passengers and 1 driver. Contention that phrases any person and any passenger in subclauses 1 and 2 of section 147(1)(b) are of wide amplitude and cover the Kalasi as a passenger. Alternate submission that deceased was a conductor. Whether the risk of a Kalasi is covered and insurance company is liable, held no. Policy covers the risk of driver, conductor, or examiner of tickets.
Which paragraph did you read now?
I read the head note, my lord, but it says para 10, 12, 13, and 15 to be referred.
Ramashraya Singh case ತಾನೆ ಓದಿದ್ ನೀವು?
ಹೌದು. Para 10, after about 15 lines.
It says claim is unsustainable ultimately. In Ramashray.
It requires little examination.
Tariff for goods carrying ratios.
ಇದು act only policy ಆಗಿ ಅದಿದ್ರೆ ಸರಿ, but what about
ಈ ಕೇಸ್ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅಂತ para 15, last 3 lines. So David, para 14 ondsali request my lord to kindly.
IMT 28 ಇದ್ರೆ ಒಂದು ನಿಮಿಷ, IMT 28 ಇದ್ರೆ legal liability to persons employed, regularly paid drivers or cleaners in connection with operation and maintenance of the two-wheeler under the Workmen's Compensation Act and at the ಅಲ್ಲ ಇದ್ರದ್ದು
ಅಲ್ಲಿ ಪಾಲಿಸಿನಲ್ಲೇ ಇರುತ್ತೆ IMT 28, ಆ ಪಾಲಿಸಿನಲ್ಲೇ ಕೆಳಗಡೆ ಇರುತ್ತೆ IMT 28. para 14 ಒಂದ್ಸಲಿ ನೋಡ್ಬೋದು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ರಾಮಶ್ರೇಯಸ್ para 14.
IMT ನೋಡ್ತೀನಿ. IMT 28 ಬರಲ್ವಲ್ಲ ಇದಕ್ಕೆ, tariff for commercial vehicles. Carrying capacity ಎಷ್ಟು ಇದರಲ್ಲಿ?
33.
I have the IMT 28. If I
That is for a two-wheeler. I think that is wrongly used here. If that is to be adopted, it includes drivers and cleaners.
the legal liability to paid driver / conductor or cleaner employed in connection with the operation of insured vehicle. This requires an additional premium to be paid.
Here the IMT 28. Legal liability to paid driver and or conductor and or cleaner employed in connection with the operation of an insured vehicle. Bracket for all class of vehicles. In consideration of an additional premium of ₹25, notwithstanding anything in the contrary contained in the policy, is hereby understood and agreed that the insurer shall indemnify the insured against insured's legal liability under the WC Act, Fatal Accidents Act, or at common law and subsequent amendments to the Act prior to the date of endorsement in respect of personal injury to any paid driver and or conductor and or cleaner whilst engaged. So IMT 28 use matter cleaner ಬಂದೇ ಬರ್ತಾರೆ. IMT 28 ಬರುತ್ತಲ್ವಾ ಎಲ್ಲ?
ಅದೇ IMT ಅವರು ಅಡಿಷನಲ್ ಪ್ರೀಮಿಯಂ ಕೊಟ್ಟಿರ್ಬೇಕು.
ತಗೊಂಡಿದ್ದಾರೆ. 25
ಮೊದಲನೇ ವರ್ಡ್ ಅದೇ ತಗೊಂಡಿದ್ರೆ
IMT 28 ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಬರುತ್ತಲ್ಲ ಆಟೋಮೆಟಿಕ್. ಬಟ್ they have a choice ಅಲ್ವಾ to go either and ಎಂಪ್ಲಾಯಿಗೆ ಕವರ್ ಆಗುತ್ತೆ ಅಂತ ₹25 ಇಸ್ಕೊಂಡ್ರೆ if but every person has a choice either to go into the WC Act ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, compensation awarded, my lord. There was a accumulation of blood in the left kidney, my lord, due to the accident. Then, my lord, blood, my lord, in the left kidney, my lord.
Miscellaneous amputation of
Accumulation of blood in the left kidney, my lord. Lordships get at the injuries, my lord. Lordships get it at page 11 of the judgment, top portion, my lord. The disability and the injury suffered was stated, my lord. He was inpatient for a period of 15 days, my lord, in the hospital.
But what is the permanent damage?
My lord, as per the evidence of PW2, my lord, and disability certificate, he has suffered 15% disability to that because of that injury. MACT reckons, my lord, 5% disability to the whole body and awards compensation towards loss of future income, my lord. The monthly income assessed is at 4,000, my lord. As per the Legal Services Authority, my lord, it is 4,500. Page 11, my lord, PW. There was awards under other heads also, my lord, was not awarded. Loss of amenities is not awarded, my lord.
1052/2012. The claimant seeking for enhancement. In MFA 10357/2010, is by the insurer. In this case, the claimant contended that he was working as a cleaner in a bus, and the said bus met with an accident when the driver of the bus lost control and the bus capsized and fell on the road, which resulted in grievous injuries to him. The tribunal, after assessment of the evidence, came to the conclusion that the claimant had suffered an injury to his kidney, and it proceeded to award a sum of rupees 66,200 as compensation. The insurer has filed an appeal challenging the said award on the ground that the claimant will not be entitled for any the insurer will not be liable to pay the compensation since the claimant was admittedly a cleaner in the bus. It is contended that it's only a paid driver who would be covered under the insurance policy, and therefore the award making the insurer liable was unsustainable. The counsel for the insurer for the claimant on the other hand contends that the medical evidence then contends that this argument of liability cannot be sustained since additional premium was collected under IMT 28, and if the endorsement IMT 28 is found in the policy, then it will have to be assumed that the insurance has a liability to pay compensation in respect of drivers and or conductors and or cleaners. As far as compensation is concerned, it is contended that though the doctor assessed 15% disability, the tribunal has only granted 5%, which is impermissible. It is also stated that the income assessed by the emotional income assessed by the tribunal at rupees 4,000 per month is also on the lower side. The insurance policy was produced by the insurer as Exhibit R1. The said policy indicates that sum of rupees 25 was paid to cover the paid driver bracketally endorsement IMT 28. IMT 28, the endorsement IMT 28 is described as follows in the IMT, page 194. As could be seen from the said endorsement, the insurer would have a legal liability to the paid driver and or conductor and or cleaner for all classes of vehicles if the term IMT 28 is found in the policy. In this view of the matter, even if it is assumed that the claimant was a cleaner, the compensation that the insurer would be legally liable for the compensation. There is thus no merit in the appeal of the insurer and is therefore dismissed. As far as compensation is concerned, the tribunal has determined the notional income at rupees 4,000 since there was no documentary evidence. As the accident is of the year 2000, 2008, to be appropriate to apply the notional income determined by KSLSA, which would be rupees 4,500. The tribunal has reduced the disability to 5%, though the doctor had stated that the claimant had suffered a 15% disability. In my view, since the claimant had suffered an injury to the kidney, it would be appropriate to accept the assessment of disability by the doctor at 15%. Consequently, the claimant would be entitled to compensation of 4,500 into 18 into 12 into 15%. The tribunal has awarded a sum of rupees 6,000 towards medical expenses, and the same is affirmed. Over the sum of rupees 2,000 awarded towards incidental expenses. is enhanced to rupees 15,000. The amounts awarded towards loss of earning shall also stand proportionately increased to rupees.
ಎಷ್ಟು ತಿಂಗಳದ ಮಾಡಿರೋದು ಲೇಟ್ ಪೀರಿಯಡ್?
ಕೊಟ್ಟೇ ಇಲ್ಲ ಸರ್.
43,200 ಕೊಟ್ಟಿದಾರಲ್ಲ ಲಾಸ್ ಆಫ್
That
ಅರ್ನಿಂಗ್.
is loss of future income due to disability, my lord.
The claimant was laid up due to an injury to the kidney, be appropriate to take the laid up period as 3 months and award some more rupees 13,500. That's good. Consequently, the claimant will be entitled to the following. The appeal by the claimant is allowed on factor. ಕಾಣ್ತದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಯಾವುದು ಮಾಡ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 2000 ನಾನು 2015 ಅಲ್ಲಿ ನಿಮ್ಗೆ ಕೇಳಿದಲ್ಲ 2012 ಅಂತ ಅಷ್ಟೇ ಕೇಳ್ಕೊಳ್ಳೋದು. ಸೆಕೆಂಡರಿ ಹೇಳ್ಬೋದು ಕೇಸ್. ನೀವೆಲ್ಲ ಬೇರೆಯವ್ರು ಕೇಳೋ ಟೈಮ್ ಒಪ್ಕೊಳ್ತೀರಿ. ರವಿಶಂಕರ್ ಟೈಮ್ ಕೇಳೋದು ಇಟ್ಸ್ ನಾಟ್ ಅಕ್ಷಮ್ಯ ಅಪರಾಧ. ನೆಕ್ಸ್ಟ್ ನೀವು ಇದೆಲ್ಲ ಸಾಕು. ನೆಕ್ಸ್ಟ್